Members of Parliament, support staff, radio listeners, TV viewers, all following this meeting via social media, members of the media, ladies and gentlemen, I welcome you to the continuation of public meeting number 19 for today, Wednesday, June 10th, 2026. We have established a quorum of 10 members, and I invite you to stand for a moment of silence. Thank you. At this point in time, I want to say a special happy return by our Acting Secretary General, Mrs. Jessica Duzong-Weeks, who has been out on maternity leave and is back with us now. We are happy to welcome you back, Jessica, and thank you for being here. In terms of notices, I have received a notice of absence from MP Peterson, also from MP Lacroes, and lateness from the member De Weaver. Are there any notifications from the floor of Parliament at this time? I see MP Duran is requesting such. MP Duran, you have the floor.
Thank you, Madam Chair. Good morning to you, my colleagues, the Prime Minister, his support staff, and a special shout out to the people of St. Martin that are tuning in. Madam Chair, I believe in this digital realm, in this digital world that we live in, everything is recorded, so nobody can hide behind anything. Of course, there's also always people that want to spin narratives, which is always possible. But I just want to say something for the record that I heard over the last, I would say 36 hours or maybe 48 hours, and I just want to bring it clear to the people of St. Martin. Madam Chair, I took office, the Jacobs 1 cabinet took office in November of 2019. During that period, a vacancy was put out for the C levels of GB, the O levels, so all directors of GB. Therefore, under the Jacobs cabinet, no local individuals were fired from GB. Not Miss Iris, not Veronica Jansen-Webster, who's currently here, and nor Mr. Chittick. Christopher Weaver was the minister in charge of Rummy, and under that tenure, the vacancies went out. I just want to make that very clear because I heard some disturbing statements coming from more to the URSM side, and I just want to be clear to the people of St. Martin. To the contrary, the National Alliance under William Allen appointed those local individuals. So therefore, we have to call a spade and be very, very clear. And I challenge anyone here, at least 2 persons in this room have the opportunity to rebut and clarify if that's not the case. Therefore, we did not fire them, we hired them. Thank you very much, Madam Chair.
Thank you, MP Duran. I continue with the floor for notifications, and I give the floor to MP Ottley. MP Ottley, you have the floor.
Thank you, Madam Chair. Madam Chair, let me start by wishing my fellow colleague, MP Lacroes, and his family much success. He's on a way medical trip with his son. Of course, he did give me the approval to mention this publicly, so I would like to publicly wish him, his family, and his son speedy recovery. Also, Madam Chair, speaking of GB, a ship without a captain. Madam Chair, we are seeing a blunder, a mess. And that meeting is to come on Friday. So I do hope that it does happen on Friday, and I'll dive in more to the issues of GB then. Thank you, Madam Chair.
Thank you, MP Ottley. I don't see the need for any further notification. So members, we continue with the agenda points for this public meeting. And namely, the agenda point being deliberations with the Prime Minister addressing the recent allegations of integrity breaches concerning the Prime Minister's involvement in the affairs of the Ministry of Public Health, Social Development and Labor. This document, so the request for this meeting, is registered under number IS 926, and it's dated April the 7th of this year. It was requested by the members Ottley, Lacroes, and Lewis. I want to make note of the fact that as this is a public meeting, the chair may permit interruptions during the discussions. I ask the members to observe the guidelines regarding interruptions. Make sure that these are short. You can ask something to be that is said be clarified. You can make assertions on the topic, and you can also add additional information to something that is or has been said. So we continue with the agenda point after that brief announcement, and I mentioned what the topic is here today and who have requested the meeting. I mentioned that the meeting was requested on April the 7th, and it is registered for the Members of Parliament's notification on the IS 926. This meeting started actually on May 25th, and at the start of the meeting, the Prime Minister gave a presentation. Members were given the opportunity to pose questions to the Minister in the first round, and the meeting was then adjourned to allow the Prime Minister sufficient time to prepare the answers to the questions posed. So at this time, I want to give the floor to the Honorable Prime Minister and Minister of General Affairs, Dr. Luc Mercelina, who will make his opening remarks and answer the questions posed by members of Parliament in the first round. Prime Minister Mercelina, you have the floor.
President of Parliament, Secretary General, once more welcome. Members of Parliament, those following by social media, my technical support staff sitting to the right of me, and of course the people of St. Martin, good morning. Madam Chair, we have had the first round already of this parliamentary public meeting. I'm going to, with your indulgence, I will go immediately in answering the questions that have been posed to me in the first round. I will start with MP Ottley. His first question is, did a tender go out for the position of a legal professional? Actually, he said, did a tender go out for that position? But just for us to be informed about what he meant is for the legal professional in legal affairs. And of course, did any job vacancy go out publicly, or was this person just hired into YZ and Way? The answer to the first question is, it is noteworthy to mention that there is no tender requirement. I repeat, there is no tender requirement for the filling of position in government, or in this case of legal affairs. There was a job vacancy, and hiring went in accordance with the procedures assisted by the Department of P&O. The second question of MP Ottley. The MP mentions that he was the Minister of VSA, and the Prime Minister did mention Article 3 correctly. It is of the discretion of the Minister that the Prime Minister was the acting Minister, and while you held authority, did you consult with the Minister of VSA before taking such decision? The MP mentions that he was also the waarneming, the acting for many other ministries, and before taking decisions that would reverse the ministry's decision, he would consult with the sitting minister. So his question to me is, did the Prime Minister, as acting Minister of VSA, did he consult the Minister of VSA while he took his decision? The answer is no. I did not consult with the Minister. However, it is important to note that the signing of the advice and the memo recording my justification for the signing of need accord are both dated November 8, 2024, before Minister Brugge came into office. So this, what we're discussing, is even before the tenure of ex-Minister Brugge. The advice was brought to me by the Cabinet of V.S.A. for signing, and as I was the acting Minister of V.S.A. at the time, I decided to sign this advice. It is also important to emphasize that the advice in question, which Parliament has a copy of, was based on the denial of a renewal of an exemption. We have to understand that good is not asking permission for the establishment of a brand new practitioner in St. Martin. No, it's a practitioner that has been working already in St. Martin, and we are asking an exemption for the extension of this candidate. It is also important to emphasize that the advice in question, which Parliament has a copy, as I said, was based on the denial of a renewal of an exemption, not the provision of an exemption. It's not so, please provide us with an exemption. No, please provide us with an extension that existed already of an exemption. It's a big difference. What we try actually to inform the people of St. Martin with is if so we are doing something new. No, we were doing it with an exemption, and the request is if we can extend a pre-existing exemption. That was the request, meaning that the doctor in question had previously had an exemption granted already. So it's not a new candidate that comes to work in St. Martin. No, they're asking me as the acting minister, Minister, can you agree for us to extend a pre-existing extension? So that is something completely different. The first exemption was actually granted on February the 3rd, 2022, during the term of the former Minister of V.S.A., MP Ottley.
Prime Minister, with your indulgence, I'll allow MP Irian to make an interruption at this point. MP Irian.
Thank you, Madam Chair. Madam Chair, thank you for allowing the opportunity. I heard a statement through Madam Chair, also from the Prime Minister under his radio interview the other day, and I want to be very clear to the people of St. Martin, and I don't want, and I'm hoping that the Prime Minister isn't trying to misspeak. The Prime Minister is stating, Madam Chair, that the former Minister of VSA gave he extended what was already there. So my question to the Prime Minister, Madam Chair, is, was the person already practicing as a GP, or were they working in a medical center as a floor operation person? So, because you're saying you extended it. You didn't extend their position and what they were practicing. So be very clear to the people of St. Martin, Prime Minister. Thank you.
Thank you, MP Irian. MP Irian, did you, in your interruption, refer to me as well, a statement? Through me. Okay. Thank you, MP Irian. We continue, and Prime Minister, if you can, address the interruption raised by MP Irian, and continue with your discourse. Prime Minister.
We are talking
Yes.
the function in which the person is evaluated in is as a general practitioner. So when you have the case in front of you, you're going to ask yourself, what is the credentials of this candidate? So it's a general practitioner. So this doctor today is still a general practitioner. And as I said, and I will come back on that, there are a lot of general practitioners that function in the hospital but also outside the hospital. But I'm going to give you now further the document that I have here for you, in which we are actually having some doubt about the judgment of this acting minister of ESA about the extension of the exemption, while the same extension of exemption was given the 3rd of February 2022. So it's just for you to know that it's nothing new that I'm doing, and I'm going to add to it correctly the former minister that I'm going to add to it correctly gave the extension of the exemption. So I'm not criticizing him on his judgment to give the extension of the exemption. Absolutely not, because on the base of how he decided to give the extension on the exemption, that is the same that I did it for this doctor.
Thank you, Prime Minister. MP Ottley, you still have a further interruption. You may proceed.
Thank you very much, Madam Chair. I'd like to thank my colleague for that, because I noticed when the question came about, all of a sudden it's twisting and turning and the roads went from straight to curve. What I have here from the RAD from Advice, a request went in May 2024 for this person. May 2024. On the Council of Public Health. The Council of Public Health advised a request went in May 2024. On June 10th, 2024, advice was given. The council has carefully studied whether to grant or not. And it says they are vehemently against such. It is also appears from the big registry, right? And basically the advice is not. The person has not completed the practitioner training. As a result, she cannot function independently. I would like to make it clear, Madam Chair, that when the person was approved during my tenure, it was based on ER. And based on those regulations, there are different ways, means, criterias, and experience in which a person is allowed to practice. But Madam Chair, we look at this date here, 2024, it went in, Madam Chair. 2024.
Thank you, MP Ottley. Prime Minister, do you need a few minutes just to address this matter extensively, that we can get it clear, or you have all the responses and facts available there?
Yes, I have the facts available. The recommendation...
You may proceed then, Prime Minister.
Thank you, Chair. The recommendation for the Council of Health states that she has permission to practice as a GP in the first line in the community of St. Martin. We have that advice of the Council of Health, and with your indulgence, Madam Chair, I will send that document to you, that there is approval with some conditions that this doctor can work in the first line healthcare of St. Martin. And I think that we have the document here with the approval of the healthcare, because that is the one I'm looking for. And we have the document stating the following, but I will come back the moment my technical assistant here has the document, but for sure, in my preparation, I encounter this document.
Okay, Prime Minister.
Yes, I will continue then?
Yes, you may
Yeah,
continue,
you.
and we look forward, and it shall be noted.
Yes.
That we'll receive a document to which you are referring.
Oh, yes.
Oh.
So you have it here, the Council of Health? Okay, but they have it, they received it already, they confirmed. So it's only confirming what I said. Okay.
Prime Minister, you may continue.
Yeah, thank you, Madam Chair. Madam Chair, through you, since I signed neat accord to the denial of the renewal of this exemption, no follow-up has been done concerning authorizing this doctor. So she requested for an extension, and she did not get an official, although the fact that I have signed neat accord doesn't mean that all paperwork has been finalized for her to get the official correspondence that she will be permitted to work in the first line of healthcare in the community of St. Martin. So the doctor never received an answer on her request. Question 3. It was advised for this person, the general practitioner, to do actually the opleiding, and the MP was told that the acting minister refused this. Is this true? Bon.
Before you go into whether that was true or not,
Yeah.
MP,
Yes.
Prime Minister, will allow MP Ottley to make an interruption.
Madam Chair, thank you. Madam Chair, for the public, there's a difference between a medical doctor and a general practitioner. A medical doctor is something you can achieve, and he correct me, he's shaking his head. A medical doctor, when you finish school, you're considered a medical doctor. To be a GP, you need specific training to go ahead. What the person was approved under my tenure, 100% facts, was as a medical doctor, which you can operate not as a GP. The Honorable Prime Minister, against the advice and of the public of Council Health and the department, put the person as a GP. Stop fooling the public. There is a big difference. The public may not understand, but there's a big difference between an MD and a GP, Madam Chair.
Thank you, MP Ottley. And just a reminder so that we can keep the flow of the meeting that the interruptions must be short and to the point. The Prime Minister, you may continue.
Thank you, Madam Chair. Madam Chair, there is the term general practitioner when you finalize your academic education as a physician. You come out of the university benches, and the only thing that you can apply for is that you are a general practitioner. Next to being a general practitioner, I'm explaining this as a medical professional myself, there is a next position, and that is a family doctor. So there is a difference between a GP and compared to a family physician, what they call a family practitioner. The difference is that that is a further specialization next to being a GP, in which you follow a course that especially concentrates on preventive healthcare, children healthcare, and elderly healthcare. That is an additional course that you follow, and once following that, you are then a family physician. Please, let us not confuse the people of St. Martin while there is a professional standing here trying to explain how that world is functioning. Please. Secondly, it's important to notice, and I said it already in the past, if you Google a country like Colombia or Venezuela, those doctors come out of the university. You can Google it now if you want, and you ask about if a general practitioner can go outside in the field, ask a permission to establish as a doctor and function as a GP, as a general physician. That is possible in Colombia and, for example, Venezuela. In the Netherlands, that is not anymore possible. You cannot come out of the university benches and all of a sudden then think in the Netherlands that without a subspecialization as a family doctor, that you can practice as a house doctor in the Netherlands. These are just the regulations for countries. So please, let us not confuse the people of St. Martin concerning this. But I have the patience to continue explaining if it's necessary.
MP Duran, you may have your interruption, and I would want to advise the Prime Minister. I listened to this point. I see it doesn't seem to be totally clear, and Prime Minister, I would ask you to give that summary and explanation. If you can just prepare that on paper for all members, and if eventually submit it to Parliament so that everyone would understand. But in the meantime, because I really want to get beyond this point, but I gave MP Duran the possibility for an interruption. MP Duran.
Thank you, Madam Chair Lady. Madam Chair Lady, I think it's important for us to go back where this conversation started. I remember coming here to the interruption lectern, asking the Prime Minister to clarify what he said. And he mentioned that all the certifications weren't in order, but the reason why he took the decision, because he knew the individual and he could stand by it and guarantee. Now we're hearing about Colombia, we're hearing about Venezuela, which is all well and fine. I think the general public could rest at ease knowing, was the person certified, qualified based on our laws and regulations to practice in the position that it was granted in St. Martin? I think that alone in itself will bring clarity to everyone, because right now I'm hearing a lot of terms being used. General practitioner, medical doctor is not allowed anymore, the certification. But I think that alone, and Madam Chair, your request for a letter with it on black and white is also very much welcome. But I would just like clarity on that point, because it wasn't me that said the lady wasn't qualified or the individual wasn't qualified. The Prime Minister said that, and he also stated he'll stand by it because he knew the individual. Thank you.
Thank you, MP Duran. So, Prime Minister, again, you may continue, but if you can just give that total elucidation, GPs, general practitioner, family medicine, et cetera, and as an addition to this discussion, that would be appreciated. Prime Minister, you may continue.
Thank you, Madam Chair. I will give the explanation on a document that will be sent to explain the difference between a general practitioner and a family doctor. Question 3. Can the Prime Minister confirm or deny whether he called an urgent meeting to demand the adjustment of the terms of references in order for the Prime Minister's candidate and profile to fit each other? I did not call an urgent meeting to demand adjustments to a terms of reference. That is the answer that I can give to the Member of Parliament. A other question was, did the Prime Minister personally send proposed adjustments to the Secretary General of VSA? The answer to this one is the TOR, being the term of references, had been sent to the Secretary General for discussion purposes. Question 6. How is the person contracted to create the draft for the BIG presented by the Prime Minister to the Minister of VSA? The answer is, as Prime Minister, seeing the inherited legislative needs of the country, was able to source a legislative lawyer which has then been hired into legal affairs, and that was on the basis of a vacancy. And with that, in that way, through legal affairs, this patient was then contracted to come work in the government organization. We had a few legislative initiatives that we wanted to work on. One of them was the BIG, the Healthcare Professional Registry. One more that coincidentally, after finalizing the BIG draft legislation, the healthcare professional registry that we're talking about. She is now busy, for example, with the screening from candidate ministers. Every time after election, it's a whole discussion how a candidate minister should be screened. And I have discussed that, and we decided that we're going to try to help the country and see if we can come with the ultimate landsverordening, national ordinance, to put all of this in place for us not to constantly encounter this discussion about how candidate ministers should be screened. Another one is the placement of civil servants in cabinet of ministers as political appointments. That is also a very challenging thing that is going on, that we don't know right how to do that. In the past, we used to give them a contract, and then from the governor's side, the landsbesluiten were not signed anymore, so we are trying also to make a legislation concerning that. Further, we agreed with this legislator that after that, she will work on the electoral reform and also on the topic of a democratic deficit. I think these are big things that every year again are being discussed, and at a certain moment, somebody just has to sit and try to draft the legislation for all of that. So that is all until now, and there shall be more of them in the future, but I think these are important ones. The next question is the person being paid by public funds? Of course, the answer is yes. The person is being paid by the public funds based on a contract, which is a common practice when candidates are hired. The other question is, did you or did you not ask the TWO representatives on different occasions to bypass the ongoing bid procedure? The answer is no, I did not. I proposed to the TWO to consider, though, this candidate due to the fact that this candidate was experienced with the drafting of legislation. That's one. Secondly, that she was qualified as a draftsman and has worked a few years also by the Council of Advice. This person already, of course, was completely familiar with the topic of the HCPR because she was working already for me before the TWO came with the store. And as such, I recommended the TWO, why are we going to look for another legislator while we have one already that is completely in the materia of the drafting of the law for the healthcare professional? I think this is something great for St. Martin. If one day we can have a great law that organizes and gives clarity about how we're going to select medical professionals for the community of St. Martin. Question 9, did you not tell on different occasions, including the meeting held with the representatives, to bypass the bid process? I said already no. I did not suggest bypassing the bid process. I just suggested that the legislative lawyer that was currently working already on the HCPR, the Healthcare Professional Registry, and of course that she was qualified and knowledgeable about the topic already, to please consider her, because she is already in the stuff. Why are we going to hire a new one while we have one that was almost ready with the draft legislation? I don't see nothing wrong with that. Question 10, did you or did you not provide confidential information on the bid to this specific candidate at the time she was working on the Council of Advice? The answer to this question is no, I did not. I'm not aware of any confidential information on the bid. If the MP is referring to the TAR, it is a public information. So if you're talking about the TAR is something that we publish, and it's a public information, so there is no confidentiality if we're talking about the TAR. Question number 11, how do you explain the instructions to the Secretary General to amend the tender? The answer to this questionnaire, there were no instructions to the Secretary General of VSA to amend the tender. As I said, the tender was sent to her for discussion purposes, but there were no instructions from my side to amend the tender. Question number 12. What are the legal powers that the Prime Minister has in our current democracy to withhold another minister's advice from the Council of Ministers? The answer is, as mentioned in my last presentation, the chair of the Council of Ministers is the one who decides on the establishment of the agenda in accordance with Article 16 of the Council of Ministers Rules of Order. In that context, any advice of any minister can be discussed before it's added to the agenda. In this specific case, there were multiple discussions with the former Minister of VSA on agenda points for the HCPR, for the BIG, and in such case, as long as there was no clarity, it would not go on the agenda of the Council of Ministers meeting. Question 13. I will give the Prime Minister another opportunity to motivate, possibly to us, why, other than I knew the person, was this person working illegally as a general practitioner, and was the person registered as a ER doctor? It is important to clarify that mention of knowing this person was in a professional capacity. So I knew this person in a professional capacity. I have worked as a professional in the hospital with this doctor, and such I'm familiar with her professionalism, her knowledge, skills, and credentials. These credentials were also part of the advice. Once again, as Prime Minister and Acting Minister of VSA, I was brought an advice for approval brought to my attention by the VSA Cabinet. Moreover, I received a negative advice for a denial of the renewal of an exemption that had previously been granted to the doctor in February 2022. Based on the advice that was presented to me and the underlying documents, I did not agree with the advice to deny the extension of the exemption. One of these underlying documents was an advice from the Health Council that stated they had no objection, and that is the document that I have to send now to Parliament. The Health Council states that there is no objection of the doctor being established as a doctor, a house doctor, provided that she works under the supervision of a house doctor. That is what the advice of the Council of Health was in that time. By the way, and now that is for you to understand this whole difficult concept of house doctor and GP. The Health Council sends an advice and say we have no problem for this doctor to work as a doctor in a family practice under one condition, that she is being supervised now by a house doctor. So she has been placed in a family practice from a family doctor. And if we understand the dynamics, this doctor now that has been working, I think, more than 20 to 25 years, very respected, knowledgeable, and qualified doctor, is a doctor that does not have the certificate to be a family doctor, but still is practicing as a general practitioner. Under this knowledge, it has been accepted by those before me too. So we are giving an advice, we approve it, and then all of a sudden, if you know, you understand that the older doctor that is working in that practice does not have the required papers that nowadays they are putting because they want to follow the Dutch system. But that does not mean because all of a sudden the Dutch system say only family doctors specialized in family medicine can execute that work. That doesn't mean the one that has been doing it 15 to 20 years in that time, not having that specialization, all of a sudden at that particular moment becomes unqualified. So we have to understand the dynamics, how in generally this system works. Furthermore, I will refer to the MP, to the memo I included with the advice in which I provided my justification for my disagreement with this advice. In that memo, I detailed the following reason. The doctor does not formally qualify as a family physician under the national ordinance regulating the practice of medicine. Her substantial local experience and track record merit makes that we strongly consider her adequately and qualified to work in the field in St. Martin. She has had an extensive career also in St. Martin Medical Center, working for the Department of Surgery, orthopedic surgery, internal medicine, pulmonology, and oncology. So it's a doctor that has go through a lot of departments in the hospital after having the qualification of a GP. Additionally, there is a pressing demand for qualified medical professionals in family practice, and given again the aging of this group of family doctors, and combined with the growth of the populace in St. Martin, realizing also the amount of family doctors that in the 5, 6, 7 years have actually retired, there is an urgent need for more doctors to work in St. Martin. Focusing only all of a sudden on family doctors now to think that you're going to get these professionals to work in St. Martin, even in the Netherlands that have abundant of these professionals, is not going to work. So what are you going to do now? You're going to tell the people that are sick, sorry guys, we do not have a general practitioner, a doctor to look at you, because the requirement is in the Netherlands. Not in Venezuela, not in Colombia, no, in the Netherlands. They need an extra certificate. So sorry everybody in this country, we are not going to supply you with any doctor anymore, because in the Netherlands, in their situation, they decided that they want an extra certification before a doctor can work in a family practice. And I think at a certain moment, with the laws that we have, it's possible for us to give exemptions in a way to continue giving adequate care in a sustainable way for the people of St. Martin. I believe that in the case of this doctor, there was a justification for deviation from the standard regulations, and Article 3 of the National Ordinance regulating the practice of medicine provides an avenue for that deviation. Actually, the former Minister of ESA also made use of this provision. Question number 14. Did the ministry offer the opportunity for opleiding for this person? The answer is the ministry brought a negative advice not to allow an extension of the exemption, and it was not part of the requirements of the Health Council, who have not objected to the doctor's establishment as a house doctor. So even the Health Council did not have that requirement when they gave that permission for her to work in a family practice. Question number 15, will the same urgency be taken for the others that were denied? I do not understand of which urgency we are talking. Based on the advice, obviously there was no urgency. The initial request was made in May 2024, and the advice was brought from the Cabinet of ESA to my person as acting Minister of ESA on November the 8th, 2024. So the request is in May. Imagine how slow we work in this country. In May 2024, we get a decision on it on November the 8th, and then the MP asked, why has this been dealt with so urgently if we also do that for others? If we consider already May to November as urgent, imagine how we should have to handle this country with urgent issues as providing doctors to take care of the people of St. Martin. I do not think this type of politics should be played for our people. Question number 16. How do you think the working relationship will be now with the Department of VSA moving forward? I assume the MP is referring to the Ministry of VSA and not the Department of VSA as in the question. The context under which this question was asked is no longer the same given the motion of no confidence that was subsequently tabled and approved in Parliament in May the 29th, 2026. Question number 17. How is your relationship with the Department
Prime
VSA
Minister?
at the moment?
I see the MP, in this case MP Irian, is asking for the floor. The only reason the MP can ask for the floor at this time is by a proposal of order. And the proposal of order has to do with the handling of the topic at hand. And your proposal is MP Irian? Yes.
Thank you, Madam Chair. Madam Chair, I would like to propose through you that the Prime Minister answers all questions posed to him and not decide for members of Parliament what is not necessary anymore because a motion of no confidence was passed for the Minister of VSR. So I propose that all answers about proposed to the Minister that gets answered, and not that the Prime Minister decides which get answered or which don't get answered. Thank you, Madam Chair.
Thank you, MP Irian. I wouldn't really, before anyone says seconded, I really wouldn't consider that a proposal of order. However, it having been asked, I'll just ask the Prime Minister to take note of what was said. Thank you, MP Irian, and Prime Minister, you may continue.
Thank you, Madam Chair. Question number 17. How is your relationship with the Department of VSA at the moment? Obviously, when the minister was there, I was the acting minister only when the minister was away. Now, in this traditional period, I intend to work closely with the Secretary General of VSA, along with management team of VSA, supported by the Cabinet of VSA, as we go through the process of finalizing a new incoming minister of VSA as quickly as possible. Question number 18. What is the draft person being paid? Where are they being paid from? Is it as a consultant? Is the question of the Member of Parliament. The answer to this question is, as already mentioned, the legislative lawyer being referred to is on the payroll of government, and specifically it is being paid from via the Department of Legal Affairs. Question number 19. If no vacancy went out for this person to be hired in YZNW, how did that process go? The answer is, as mentioned already, there was a vacancy for this position. Coming now to MP Roosburg. How will this relationship, if this decision will have to continue, how will this relationship function, and how will the Prime Minister, as the head of the Council of Ministers, be able to secure that the country of St. Martin will not be at risk? The answer, MP Roosburg, is it would have been very difficult to function under such circumstances, but however, in the meantime, the situation has changed. The second question of MP Roosburg is there any way to be seen that this relationship can work? Answer is, since this question was asked, the circumstances have fundamentally changed, and therefore the question in this context is not more applicable. Question number 3 from MP Roosburg. If the Prime Minister is willing, he has a package of information to provide through the confidential road so that we can receive, if it's possible for us to receive that. Relevant documentation and information was provided on May the 29th, 2026. Also, additional information was provided today with the request that it be treated in accordance with the confidential procedure. We are moving now to questions from MP Lewis. Decisions that the Minister of VSA probably made unlawfully according to the Prime Minister. How is it that those discussions reached the board? Once more, decisions that the Minister of VSA probably made unlawfully. according to the Prime Minister. How is it that those discussions reach the board of URSM? Answer is, the matter came to the board through complaints from workers in the Ministry of VSA, along with other stakeholders, directly to the board. So I did not go there and give that information. They got the information through actually whistleblowers. The board then convened a meeting with myself as political leader and Mr. Brugge to address those complaints. Question number 2 from MP Lewis. Why did the Council of Ministers not bring it to the attention of the Minister of VSA that we do not as a COM agree with the decision the Minister of VSA was making? Answer is, it is important to note that the advice awarding the contract to the husband of the Chief of Staff of the Ministry of VSA was below 50,000 Caribbean guilders as a threshold, and that would be, of course, it will never go to the Council of Ministers for the ministers to be aware of this because it was an amount under the 50,000. Furthermore, as a party, we approached our member to verify the particulars of the situation. I will also mention that regarding the tender process for the significantly larger tender awarded to this specific consultancy management that ultimately failed, 2 members of the Council of Ministers raised concerns to the board from the moment they saw the publication of the terms of references. Question 3. With all being said about integrity, was an official complaint filed at the prosecutor, the Landsrecherche, or any relevant entity on the Minister of VSA on the alleged allegations? The answer to this question is an official complaint has been filed for violation of Article 54 of the LMA, the Landsverordening Materieel Ambtenarenrecht. Now we go into the questions of MP Lacroes. Why now? If something was wrong for a year plus, why did we wait not to bring it forward much earlier? The answer for this question is, I want to make it clear once again that this matter was not ignored or left unaddressed. As reflected in the presentation in the previous sessions, concerns regarding the then minister's action were raised and discussed internally on multiple occasions. The intention was to handle the matter internally by giving the then minister the opportunity to reflect, correct course, and retract decisions or actions where needed. Unfortunately, the matter later became public. Rather than helping to resolve the situation, the then minister chose to attack me as a party leader and prime minister by constantly doubling down in media outlets internally and publicly with statements and unsubstantiated claims. Question 2. Were there any reports made to TWO, Integrity Chamber? Was anything done before today or the last months? The answer, it is not clear what the MP means by this question. Does the MP refer to reports on the wrongdoing of Minister Brugge with that contract? These contracts are related to project of NRPB and not TWO. So the projects that we are talking about that were awarded were projects from NRPB and not from TWO. As it relates to the Integrity Chamber, again, I refer to the then Minister of VSA's request to the Integrity Chamber. Myself, I didn't direct any request to the Integrity Chamber, but the Minister of VSA did. The Integrity Chamber actually contacted me, and I told them, of course, they are welcome to do the investigation that they think is necessary. All doors will be open for them. Question number 3, the Prime Minister spoke of payments. Just for regular folks to understand, because the MP wants to understand where are the checks and balances. The answer is the following. payments should be made based on the contracted amount. In this case, I said the amount was under the 50,000, to be exact, 48,510. These series of payments of that amount were made to that consultancy management. According to the advice approved by the then minister, payment was to be arranged upon presentation of an approved invoice by the minister or a designated person within its cabinet. However, in addition to these payments, other payments were also made. The total amount being paid between January 2025 and September 2025 to this consultancy management group was above the 80,000 Caribbean guilders. Actually, agreement has been made for 48, but we see already surpassing this amount, and we are already by 83,000 Caribbean guilders. It is the ministry, and by the way, ultimately the minister, who are responsible to ensure that payments are made in accordance to the contracts. So it's nobody else. The end responsibility is, at the end of the day, the minister. Question number 4, if I draft an advice to pay Paul out of the cabinet, what is the route that advice takes before the last person clicks that button to make that payment? The following has to be done. Depending on the amount, the advice needs the signature, comments of the financial controller of that ministry, and after approval of the minister, we will go directly to finance department for the payment. Any advice with an amount higher than 50,000 Caribbean guilders, needs the approval of the Council of Ministers before getting paid. Next question is, what is the difference to the Prime Minister of the S.G. and the appointment of the Chief of Staff? What is the difference to the Prime Minister of the S.G. and the appointment of the Chief of Staff? The MP's question is not clear for me what he meant with that question. I would like to get feedback on it because I would like to answer it, but I didn't understand the question. Question 6, the Prime Minister mentioned that the Secretary General won his case. Did he win the appeal? And if he did, how did he win the appeal? Yes, the former Secretary General of the Ministry of General Affairs appealed the initial verdict in his case and was successful in that appeal in May 2025. It is not clear what is meant by the question, how did he win? However, I do believe it is important to correct the implication that this government failed to act during the appeal process and that this is why the case was lost. That is simply not correct. The necessary documents and responses for the appeal were already submitted to the appeal court under the previous government already. So constantly it was taken care of that the right documents were submitted, and that appeared already to happen in March 2024. As is known, the Marcelina cabinet took office in May 2024. So even before that, in March of that year, 2024, all necessary documents were submitted for the appeal case. Furthermore, the appeal was handled by the same lawyer who has been engaged under the previous government. In addition, to avoid any misunderstanding or possible conflict of interest, on my request, the Council of Ministers decided that all matters related to this care court case would be handled by the Minister of Justice, not by me as Prime Minister and Minister of General Affairs. Madam Chair, I trust that this clarifies the matter and that this issue can now be put to rest. Question number 7, the Prime Minister mentioned that he drafted a memo and did not sign it and send it to the Secretariat. How is that possible if it had the signature of the Prime Minister? The answer to this is the following. The memo in question was addressed to the Secretary General of the Council of Ministers, to nobody else. It was prepared following discussions with the Minister of VSA after an agreement had been reached on additional points to be placed before the meeting in the Council of Ministers. For clarity, the memo was signed by me and forwarded to the Secretary General, that then should present it in the COM on the agenda to discuss, and then if there is an agreement, my memo that I signed already, the Minister of ESA would co-sign, and at that particular moment, this has validity. This is part of the normal internal process and procedures. The SG would then request the signature of the Minister of ESA, after which the matter would be placed for discussion in the Council of Ministers. In this case, the memo was signed by me, but was not co-signed by the Minister of ESA. It is important to stress that this was internal correspondence. It was not intended to be sent to anyone outside of government. It was solely for the purpose of preparing the agenda of the Council of Ministers. I have a memo. In the memo stands 2 names, 2 ministers. I sign my part already. I tell the Secretary General, put it on the agenda. We're going to discuss it, and if the Minister of ESA agrees with it, he will sign it too, co-sign it, and at that moment it is ratified and it's valid. As I have already informed Parliament, the Minister did not sign that memo. Instead, he submitted now his own draft memo, which, according to him, reflected the agreement reached. Following in the Council of Ministers further discussion, a 3rd memo was drafted and signed by both ministers. So I had a memo, he didn't agree with it. He had a memo, I didn't agree with it. And then we decided, okay, let's set up a memo that everybody feels comfortable with it. The Council of Ministers had its contribution in it, and at the end, both of us signed a document that came out of the discussion of the Council of Ministers. Nothing wrong with that procedure. Therefore, the narrative created around it and the implication that it was sent to the stakeholders is inaccurate and does not reflect the full sequence of events. Question number 8. Please help the Member of Parliament to understand if that document is not going to be shared with the whole Council of Ministers. Did that document go to the Netherlands? Obviously, a document addressed to the Secretariat was not sent, of course, to the Netherlands. There would be no reason to send this document to the Netherlands. Why should you actually, with government matters concerning St. Martin, about internal issues be sent to the Netherlands? I did not get that question, but okay, in this case, I explained that there is no reason to send this document to the Netherlands. Question number 9, when the legal advisor was hired, was she or was she not employed by a High Council of State? Answer, the legislative lawyer was formally employed at the Council of Advice. Of course, in order to accept another function, she had to resign, and that is what she did. She didn't come to work with me, by me while she's still in service of the Council of Advice. It's impossible. Question number 10, the Prime Minister is in charge of facilities. The question is, does that relate to a building, or is that after the building is built and the maintenance of the building is being done? Answer, the assumption of the MP is correct in the case of the responsibility of the building of government. However, in this combination of the NRPB project and a building, as the one responsible for the NRPB, I assumed responsibility also as Minister of General Affairs. Relevant COM decision has been provided to Parliament. So in the case of the project of the mental health facility, it is that an agreement was being made through a Council of Ministers decision on a beslissblad that in case of the healthcare, mental health care facility, that the maintenance of the building, the rent of the building, and the insurance of the building should be under the responsibility of VSA, together with the functionality of the building, while the construction of the building, to have the building ready to execute its function, that would fall under the responsibility for NRPB, and in that case, NRPB falls under the responsibility of the Minister of General Affairs. Question number 11, I heard extra funds for the building was requested and acquired by 2 previous ministers of ESA. So how can it be that it falls under the Prime Minister? The MP wants to understand that. I refer again to the MP, to my previous answer just given. The responsibility for construction of the building falls under NRPB. The maintenance, the rent, the insurance, and the functional use of the building falls under the responsibility of the VSA. As such, there is a conversation on that too, so cannot be any discussion on that. There is a conversation that the rent, as I said, maintenance and insurance of the mental health facility would fall under responsibility of VSA, while the construction of this facility falls under NRPB and thus under the Minister of General Affairs. Question number 12. Prime Minister, did you or did you not request from a former Prime Minister to disregard the established bidding process and conditions outlined in the BZK approved letter in favor of a preferred candidate for projects valued in the hundreds of thousands of dollars? The person the MP is referring to was not approached as a former Prime Minister, but in her current function at TVO. The intent was to have the input of the TVO. I did not request that the bidding process be disregarded. I suggested that the legislative lawyer be considered, as she was already busy with the draft legislation of the Healthcare Professional Registry. Question number 13, what was the opinion of Legal Affairs with that situation? The answer on this question is there was no discussion with Legal Affairs on this subject. Question number 14, was the Prime Minister told that this is against the law? Answer is, see my previous answer, I did not request that the established bidding process be disregarded. Question number 15, did the legal advisor who was dismissed before now working in the cabinet, what was his advice concerning this? As mentioned in my previous answer, the intention of the discussion with TVO was to have their input. No discussions was held with anyone other than TVO and the Minister and Ministry of VSA. Question number 16. What was the advice from the Prime Minister's board, which are lawyers? I refer to my previous answer on this subject. The board was not consulted on this matter. Question number 17. What was the advice from the Minister's cabinet when this took place? Again, I refer to the previous answer on this subject. There was no consultation with the board. Question number 18, does the Prime Minister believe it is appropriate to share confidential terms of reference documents with a civil servant employed at the Council of Advice, and if so, under which legal base? The answer to this is no confidential information or TOR documents, terms of reference documents, were shared with a civil servant employed at the Council of Advice. Coming now to the questions of MP York. It was referenced by the Prime Minister that the husband of the Chief of Staff of the Minister of ESA was taking part in construction meetings. In what capacity was he sitting in those meetings? As a representative of ESA or as a representative of SZV? That is, MP York, precisely the issue. So I found this a very good question, yours, because it was my question too. It is not clear in what formal capacity he was participating in those meetings. What we know is that he had one contract for 6 weeks for 48,000 Caribbean guilders, and all of a sudden we were seeing him participating in other activities and payments were going on. So thank you for that question. I think it clarifies a lot. However, he could not be sitting as representative of SVB as the tender was only published in October 2025, while before that he was sitting in meetings already. And mind you, for this bidding process, there were 2 advices from JZNW insinuating that there should be a conflict of interest. And then I'm talking about this Article 54 of the LMA, the Landsverordening Materieel Ambtenarenrecht. Question 2 of Mr. MP York. Does anyone from the board of the URSM have contracts with the Prime Minister's cabinet? If so, who and what positions and assignments were given? Where the assignments are concerned, how much is being paid for these assignments to these individuals or companies associated with them? The answer to this question is there is no one from the board of the URSM has a contract with this Prime Minister or this Prime Minister's cabinet. Question 3 of MP York. What procedure was followed to grant them the assignment? Was there a TAR published? Was there a vacancy published? As I said previously, MP York, there are no contracts, therefore this question is not applicable. Question number 4. The MP asserts that in the Council of Ministers, a then Chief of Staff's husband was given a contract. Was a TAR done then? Is his question. Was there a vacancy in that time? The answer is the following. After inquiry, I was informed of the following. A public tender was published and the contract awarded following the regular procedure. It is important to note that at the time of the publishing of this tender, including the TAR, the then Chief of Staff in question had already retired. MP Doran. First question of MP Doran. If the Minister of ESA isn't telling the truth, what does the Prime Minister plan to do in terms of defamation? Would the Prime Minister take him to court? The answer to this question, MP Doran, is the following. The content of the letter from the then Minister of ESA has been addressed accordingly. It must be taken into account that everything said by the then Minister in Parliament is covered by his immunity in accordance with Article 65 of our Constitution. We think that only members of Parliament has an immunity. That is not the case. Once ministers are on the floor of Parliament, they have the immunity too for information that they share on the floor of Parliament. As mentioned, after the results of the investigation by the Integrity Chamber, next steps will be decided on. A second question of MP Doran is the following. Would you file an official complaint for any potential wrongdoing? Because the MP hears Article 54 of the LMA being used, when the example was given of the former SG working as a legal advisor, he was a political appointee and not a civil servant. But when the example is given of the Chief of Staff of the Minister of VSA, she is then being termed as a civil servant and the LMA is being applied. The MP would like to know the truth of this case. And I said it already, the political appointed person, in this case the legal advisor that I had in my cabinet, at the moment of appointing this person, he is dismissed and he is not in service of the government. So there is no application then of this LMA because he is not a civil servant. On the other side, the one that is appointed in VSA, being the chef de cabinet, was a civil servant, is transferred to the cabinet of the Minister of VSA and remains a civil servant. And that means then that all laws are applicable for her because she is still a civil servant. And that means, of course, that then you can apply the Article 54 of the LMA. Firstly, again, I again refer to my previous answer in regard to awaiting the outcome of the investigation of the Integrity Chamber, the results of which, as is known, will be published on their website, allowing members of parliament to also review the results. So that means if the minister has asked for an integrity investigation, as I told you, they came to me, I told them, you are welcome, I have nothing to hide, please do what you have to do. And also, it's regulated that once they have the results of their application, it's going to be published for everybody to be able to read. Answer B. Secondly, on the different legal status of the former SG as a legal advisor in my cabinet and the chief of the staff of the cabinet of the Minister of VSA, I can inform Parliament the following, but I said it already. The former SG was dismissed as a civil servant, and actually, looking back, wrongfully dismissed because in appeal he won the case, by the way, but okay, that's another discussion, and was therefore not a civil servant at the time that he was hired by me to be a legal advisor in my political appointed cabinet. He was hired with a contract which is common for all the members of the cabinet of the ministers who are not civil servants. In the case of the chief of staff of the Minister of VSA, at the moment she was appointed in the cabinet, she was and still is a civil servant. A few years back, the governor decided not to sign the national decrees for civil servants to grant them extraordinary leave of absence to work in the cabinet of the ministers. This issue has been ongoing with attempts by both the previous government and this government to resolve. It's still a challenge. How are we going to deal with this plaatsing van politieke assistenten in cabinets of ministers? This is why the draft legislation of the placement of political assistant is such a high priority, and as such is one of the pieces of legislation being worked on by the legislator, lawyer, seconded to the Prime Minister. Because one day we can continue talking about these things, and this Prime Minister said, okay, let's stop with that talking, and every time realizing that it is a challenge for us, let's try to document this in a way in a law, and at least we have reference for the legality of decisions that we take. In the meantime, the legal position of the civil servant will remain a civil servant in the ministry for which the civil servant has a national decree. So the chief of cabinet of the Minister of VSA, the ex-Minister of VSA, the ex-chief of staff of the ex-Minister of VSA is and was a civil servant and is a civil servant. And that means, and in this case even, she is a civil servant in her landsbesluit as a civil servant by AZ. Not by VSA, by AZ. And it has not been changed because the governor could not continue signing this landsbesluit to make their shift in. So that person remained uitgeleend to the Minister of VSA, but still officially having one landsbesluit, and that landsbesluit is that she is a civil servant, is servants of AZ. That is the difference in the case of the Chief of Staff of the Minister of VSA, since she remained a civil servant in the Ministry of General Affairs and not, the way people think, VSA. It's very important to know these details. Question number 3. Can substantiated document be provided in whatever way possible if it's confidential and provided through the confidential route? The relevant information, as I said already, was provided to Parliament on May the 29th, 2026. The fourth question is, Prime Minister, do you agree that your role as Prime Minister requires you to be extra careful when involving yourself in affairs of other ministries, especially when that ministry falls under another minister? The answer is the following. As the chair of the Council of Ministers, it is my role to maintain the unity of government's policy, and in accordance with that role, it is necessary and expected that I would have frequent discussion with all ministers. I refer again to Article 16 of the Rules of Order of the Council of Ministers, in which the authority to establish the agenda of the meetings of the COM is regulated, which also provides me with the authority to discuss the advices with the ministers before adding them to the agenda. Question number 5. Can the Prime Minister explain to Parliament what you consider to be a proper boundary between coordination as Prime Minister and interference in another minister's portfolio? The answer to this is I can refer to my previous answer, and I would like to add the following. As Prime Minister, I'm also responsible for the execution of decisions of the Council of Ministers. Therefore, if the COM takes a decision and the relevant minister does not execute it, it is my responsibility and obligation to remind that minister to comply with the decision of the COM. Even if the minister disagrees with that COM decision, he will have to go with the eenheid in regeringsbeleid. That means that he will have to execute the decision of the COM. The minister will remain responsible but cannot deviate from the decision of the Council of Ministers or decide not to execute. It's not possible. I would also like to note that decisions of the Council of Ministers are legally binding and as such must be executed. Question number 6. Does the Prime Minister feel that in a way or another maybe you cross over another minister's portfolio? The answer to this is the following. Based on the questions and the narrative being developed, I'm led to believe that there is some misunderstanding regarding the function of the Council Advice, the role of the Chair of the Council of Ministers, and the ministerial responsibility. Each minister remains responsible for their ministry and remains accountable to answering to Parliament. However, the Chair of the Council of Ministers has specific responsibilities in addition to their ministerial responsibility. The Chair is authorized to add an advice to the agenda. Furthermore, the Chair is also responsible for ensuring that the relevant ministers execute the decisions of the Council of Ministers. Therefore, when the Prime Minister, in the capacity as Chair of the Council of Ministers, follow up with the Minister regarding the execution of a decision of the Council, that is not crossing into another ministry's portfolio. That is not mingling in another minister's portfolio. That is just giving follow-up for the execution of a decision that was taken in the Council of Ministers.
Prime Minister, if I may, you were earlier indicating at whose questions you were at.
Yes.
Are you still doing that?
Yes.
And if so, could you just, for clarification, give us where you're at in the answers?
Yes.
Thank you, Prime Minister.
Yes. At this particular moment, I'm answering the questions of MP Doran, Chair. Yes? Okay. Question number 7 of MP Doran. Did the Prime Minister at any time give an instruction, direct or indirect, to a civil servant within the Ministry of E.S.A. on matters that would legally fall under the authority of the Minister of E.S.A.? The answer to this question is no. No instructions were given. Question number 8 of MP Doran. If yes, on what legal basis did you do that? If no, can you explain why multiple allegations have now surfaced claiming that civil servants felt pressure or uncomfortable with your involvement? Good. Giving answer to this question, that I realize also we are trying to give some narrative that this Prime Minister is actually putting civil servant in an uncomfortable position. That is what I read out of this question 8. For clarity's sake, I would like to just go through a letter that I sent yesterday to the SG of the Ministry of E.S.A. Because yesterday MP Lacroes also made a statement in a media outlet concerning allegations that his Minister of General Affairs as Prime Minister is in all the ministries. And the letter reads as follows: I have taken note of a recent media article containing statements and concerns raised by members of Parliament regarding the Ministry of Public Health, Social Development and Labour, particularly as they relate to the protection of civil servants, advisors, management personnel and other individuals who are alleged to have raised concerns within the ministry. So that article was published because there is alleged concerns from civil servants. If that is the case, and especially now that I'm the acting Minister of ESA, I have to do something with that. So I wrote, while these assertions appear to be largely based on perception and unsubstantiated claims rather than verified facts, it is nevertheless important that the government continue to uphold the principles of transparency, professionalism, integrity, and good governance. In this regard, I kindly request that you provide me with a factual assessment of the matters referenced in the article and advise whether there have been any formal reports, complaints, or documented concerns brought through the appropriate administrative channels that would warrant further review. So if we have the assumption and perception that the minister is doing something wrong, I requested the Secretary General, please come with all complaints, documented complaints, for us to actually know what this is all about. I would appreciate your feedback regarding the existing policies, procedures, and safeguards currently in place within the government organization to ensure that civil servants and public officials can perform their duties professionally, provide objective advice, and raise concerns through established mechanisms without fear or retaliation. I think in an organization it's very important for every civil servant to feel themselves comfortable in a healthy work atmosphere zoned without a feeling of fear or retaliation. Please also indicate whether there have been any reported incidents. That is what I asked the SG, especially I was very concerned with the article yesterday published by MP Lacroes, and I took immediate action because I think this is not correct if that is the case and unacceptable, and I asked the SG please to report incidents, complaints, or evidence suggesting that any civil servant has been subjected to intimidation, retaliation, pressure, or adverse treatment as a result of carrying out their professional responsibility. So this matter has been sent to the SG of VSA for us to investigate what are the complaints, if there is fear, if there is retaliation, what is the problem, so we can document it and do investigation on that. Question number 9. Did you ever instruct civil servants to bypass their ministers, department heads, secretary general, or former chain of command? The answer is no, that was not the case. Answer number 10. Minister Brugge alleged that there were directives concerning permission for individuals to practice as a GP or medical specialist despite those individuals allegedly not meeting the legality. Is this allegation true or false? That is the question of the Member of Parliament, Mr. Duran. The answer is no again. I did not issue any directive to grant permission to any medical professional in St. Martin. What I did was on the advice, I repeat, for a request for extension of the exemption, I said I did not agree with the advice. The definite decision was not yet taken because that process had to be worked out. And as I said, until today, that medical professional did not get an answer from the Ministry of VSA. In the case of the GP, as already explained, the advice brought to me was a denial of an extension, I repeat, of an exemption that had already been given to the doctor by the former Minister of VSA. I showed you the letter too, and I assume that it's also sent to the members of Parliament. Question number 11 from MP Duran. If something were to go wrong, God forbid, in this person's care that does not have the legal requirements, who then carries that liability? Who then carries that liability? Is it the acting minister that signed it, which is in this case the Prime Minister? Is it the minister that is in the position of ESA? Is it the medical institution who carries that responsibility? Who carries now the responsibility if something goes wrong during execution of a act by a medical professional? The answer is very simple. Doctors carry the responsibility for their actions. And that's why I can tell you that profession is so stressful. I can tell you all about that because I have been working since 1999 in the healthcare of St. Martin. I have been carrying a lot of responsibility. I was a very blessed man in that profession that never had myself in a legality issue. I hope I did a great job for the people of St. Martin, but to tell you honestly, if anything goes wrong, it's to the responsibility of that medical professional, and that's why medical professionals are also so heavily insured for the case that they are sued, that there is backup in financial consequences to be paid out in case the verdict is that they made a medical mistake. Question number 12 of the Member of Parliament, MP Duran. Did the Prime Minister support, sign, promote, recommend, or pressure for the approval of any medical professional to practice in St. Martin after negative advice being issued by the Department of Public Health, the Council of Public Health, the Inspectorate, or any other competent body? Once more, I signed an accord on the denial of the request for an extension of an exemption for a medical doctor and provided my justification to the Ministry for signing as such as elaborated upon in my previous answer to the MP. Realize, I did not only sign it accord, I made a whole memo to actually explain why I'm not going in accord with the advice. I didn't give since yet. I'm just getting back to the advice that I got from the ministry. Again, for clarity's sake, the process was never finalized with granting permission with a license to that specific doctor. Just GP did never get a follow-up on her request. Question number 13. Did the Prime Minister ever sign or attempt to sign an advice decree authorizing involving medical professionals while not formally acting as the Minister of ESA? I can guarantee you the answer must be no. Question number 14. Were there cases where you were not acting Minister of ESA but still communicated instructions or preferences to civil servants regarding medical licensing? I had discussions with the former minister regarding several candidates that requested a license. I can give you an example. There are fantastic professionals working now in the Department of Urology of St. Martin Medical Center. They came in. Before that, I was part of the urology department too because I'm a general surgeon and we can cover part of the pathology that falls under urology. We were very happy when we received great professionals out of Venezuela that have proved to have given quality service to these people. I know what I'm talking about because I have seen these people working for St. Martin. We started with one. We got a second professional out of Venezuela. And now, all of a sudden, we got a third one. And all of a sudden, now the discussion starts again if those from Venezuela are qualified. Mind you, the third one coming is from the same university of the first one and the second one. And the third one is also from the same team from the other two. But all of a sudden now, there is a discussion. And I wanted to explain them that we have to try to manage logically when we're trying to help the people of St. Martin with healthcare in a responsible way, guaranteeing continuity of quality care for the people of St. Martin. Question number 15 from MP Duran. Were any of these medical professionals known to you personally? This personally seems to be an obsession, and I try every time to say that I do not know them personally. The third specialist that came from Venezuela, that I always also have understanding that he should work in. The man is coming from Venezuela. I'm still standing in for this man, for him to continue working now in Sin. I do not know that person. In the case of the discussion of the first general practitioner, that I said that I personal, what I meant with that, but if you look at the film correctly, you will understand that I did not know any of them personally, but I knew her, and I explained it just now already, in her capacity working in the hospital by the Department of Orthopedics, Internal Medicine, Neurology, and Oncology. So I did not know the person personally first. No, she came to work in the hospital. I got to know her as a professional worker, and that's why I use the word personal, but it's not more than knowing a person as a professional, working together with each other as pros to give the best possible service to the people of St. Martin. Question number 16. The MP would like to know from the Prime Minister, did you or will you benefit personally or professionally from the big registration? Actually, a very strange question. I want to bring a law in to help the people of St. Martin, and there tends to be here the idea that when somebody in government tries to do something, they always think his first trigger to do something for the community, it should be that there should be an agenda, that there is some benefit for the man in the deal. I can tell you this, Dr. Marcelina does not have any benefits with bringing a nice healthcare professional registry for the people of St. Martin. And he can tell you why. Because he knew how much stress he had in the time that he was working as a surgeon to try to continue giving quality care to people while we did not have all the necessary super specialistic specializations to help us. And if there is one benefit from this healthcare professional registry for this Dr. Marcelina, is because I'm worried who is going to take care of me tomorrow. And the same worry I have for the people of St. Martin. So the answer to this question is, the benefit I have is that I hope when I'm an older man, I'm getting older already with all the stress I have here, but if I get older, I want the best people here on the island to help our people of St. Martin with the healthcare challenges. So I have no benefit with fighting for the healthcare professional registry. By the way, you can't sell it to nobody else too, so you can't make money with it. Boom. Question number 17. If all this wrongdoing was going on from February, why did it take a year and a half to reach here? Answer, it should never have reached here. It was the former minister of VSA that brought it here, and as such, this question should have been posed to the former minister of VSA. I did not write to the members of parliament concerning this problem. He did it, so you will have to ask to him, why did we get now to here? Question number 18, does the Prime Minister think it's fair or right that we are here discussing this right now when we have so much national crisis taking place? I find it too. I agree with you guys. I don't even find it worth it to go seeing the answers that I'm giving. I'm asking myself, what is the ultimate purpose of using all this time to do this? You know, members of parliament, how much time it took me to prepare
Prime
this
Minister,
document.
if you could just direct your answers through me.
Chair.
Thank you.
Yeah, I apologize, Chair. Through you, Madam Chair, for the members of parliament to realize for a topic like this, how much time it takes a Prime Minister to come give answer to this question. And what is the relevancy of this at the end of the day? What is this going to contribute to the well-being of the people of St. Martin? This time that we were spending in this parliament concerning this, we could have used for other things, because I think that should benefit the people of St. Martin more.
Prime Minister, with your indulgence, I give the floor to MP Lewis for an interruption.
Madam Chair, good afternoon. With all due respect, Madam Chair, this is our house. And nobody, no minister dictates on what questions we pose to anybody, any council of ministers, including the Prime Minister. The Prime Minister needs to know his place in this house, Madam Chair. Thank you.
Thank you, MP Lewis. Prime Minister Marcelina, you may continue.
Question number 19 from MP Dorang. Mr. Brugge alleged that someone was engaged by you to draft the big legislation without a formal tender process taking place. Is that so? The answer to this question from MP Dorang is the following. Once again, the legislative lawyer who drafted the HCPR, or the BIG, the Healthcare Professional Registry, was hired to the Department of Legal Affairs through a published vacancy with the applicable procedures and seconded to the Prime Minister. And by the way, to initiate a draft legislation, no tender process is required. Everyone can start with the draft legislation in one or the other form. Question number 20 from MP Dorang. Was this person formally contracted? If yes, by whom? Under which budget line, or for what amount, and what procurement procedure was used? This is a similar question as was asked by MP Ottley. The legislative lawyer has been hired by the government in the Department of Legal Affairs and seconded to the Prime Minister, and as such they are paid from the budget of the Department of Legal Affairs. Question number 21. Did Legal Affairs via the Council of Ministers approve the role before she began to work? This is not relevant, as it's not a requirement for hiring a civil servant. Question number 22. Was there a formal advice supporting the engagement? The answer is yes, there is a formal advice. Question number 23 from MP Doran. Did you communicate with the SG of VSA or any VSA official regarding the changes in the terms of references for the BIG project? The answer is, as stated previously, the TAR had been sent to the SG of the Ministry of VSA for discussion purposes and not more than that. I think it's important also to realize that very difficult for me to explain the former minister that he thought that only on initiative of the TWO you could start a legislation for whatever topic. And he thought that then if you would take that initiative that you would have to tender that project. That is not the case. With or without TWO, already from 2017 busy trying to draft this legislation. And ultimately, at the end, coincidentally, the TOO said, should we focus a little more on trying to get this healthcare professional registry going while we were busy with it already. And that's the reason that I approached them and said to them, listen, we're busy with it already. You guys have it on the program to be executed and discussed because we are busy with it already. I don't see nothing wrong with that. Question number 24 from MP Doran. Did this person receive any sort of information beforehand, before the tender process, and before the tender was given? Did you get any information? By the time, the answer is, by the time the person in question had the interview for the project, she already begun working on the draft healthcare professional registry legislation as a legislative lawyer in government, and therefore was well informed about the topic. If you sit every day and you get information telling, listen, you have to consider this, think on that, this is also important for daily practice, I think at a certain moment you become a very well-informed person. So of course she had a lot of information because the time that she started the negotiation, or the time that the TWO started with the healthcare professional registry, we were almost ready with the draft legislation. Question number 25, did the selection committee ever raise a concern that the person had acknowledged or internal information that should not have been available to him or her? The answer is no concerns were raised to me. Question number 26, through you, Madam Chair. In the letter of Minister Brugge, it states that the person was asked how she obtained the knowledge of the confidential document. She alleged that you should ask the Prime Minister. Is that true? Madam Chair, through you, I was not in the interview and as such can only relay what was told to me when I inquired about this allegation. I was informed that the person did not mention the Prime Minister at any time, and as such, this allegation should not be correct. Through you, Madam Chair, question number 27 of MP Dorang. Did you ever investigate this claim, Prime Minister, or did you report it to the Integrity Chamber or any competent body? The answer is no. I never investigated this claim. I do not see a reason to do so. Question number 28. Did the Prime Minister place the big project on hold or delay the placement of it on the Council of Ministers agenda? And if so, why? The answer is, I think I have responded sufficiently already to this question, in which I refer to my authority as chair of the Council of Ministers to have the necessary discussions and debate with other ministers until there is an agreement before we can propose it to the Council of Ministers to take a decision on. Question number 29. Prime Minister, have you ever refused or delayed to withhold any advice from the Minister to the Council of Ministers agenda because you disagreed with the content and tried to convince the Minister to change said content? The answer to this is, as mentioned and elaborated upon more than once, as chair, I am entitled to have a discussion on the agenda point with the relevant ministers before adding it to the agenda. Question number 30, through you, Madam Chair, from MP Doran. Did you ever tell Minister Brugge or any VSA official, if you don't do this, it will not come on the Council of Ministers agenda? The answer is, of course, no. I again reference my previous answer on this subject, particularly my role as chair of the Council of Ministers. Question number 31. Minister Brugge alleged that confidential internal documentations were used by the board and could only have been obtained through leaks, including alleged leaks by the Prime Minister and the party leader. Did you provide internal government documentation to the board? And if so, why? Did anyone in your cabinet provide government documentations to the board? The answer is no, and that's it. Question number 32. Did the URSM board formally request any documentation through the formal legal channel? Did the URSM board formally request any documentation through the formal legal channel? De LOB-verzoek, de landsverordening openbaarheid van bestuur. The answer is, to my knowledge, the board did not request through the LOB any document of government. Question number 32 from Member of Parliament Doran, through you, Madam Chair. Did you advise the URSM board to seek documents through official channels instead of relying on internal leaks? The answer is no, that is not the case. Question number 34. Do you agree that leaking government documents for party purposes would in itself be an integrity concern? Any leaking of government documents to the press or whoever outside of government should be a matter of serious concern. Agenda point 35. The MP believes the same integrity standard that you are trying to apply to the Minister of VSA should be applied to you as Prime Minister. Do you agree with that sentiment? Yes, I agree with that sentiment. Integrity is not a standard that this Prime Minister is selectively applying to the Minister of VSA. These are common standards of integrity that all government officials, civil servants, and members of Parliament, and yes, also the Prime Minister itself, should adhere to. Madam Chair, question number 36 from MP Doran. If allegation against the Minister of VSA justifies a request for resignation, what standard applies when a similar or serious allegation are made against you? As I just stated, the same standards apply to everyone. Serious allegations must be assessed on facts, evidence, and due process. The difference in this case is that the concerns regarding the Minister of VSA are supported by documentation and evidence. They relate to concrete actions, decisions, correspondence, contracts, payments, and possible conflicts of interest. By contrast, allegations made against me have not been substantiated to me. I did not receive the documents that the minister sent to Parliament because he sent them through a confidential route. So I approached to see, is that possible? No, it's not. Why? And that is correctly, you make use of a confidential route. I cannot go and the acceptor then ask the acceptor that is making use of this confidential route to go then and tell me, okay, you have received them now, you have to give it to me. No, it's not possible. I have to respect the confidentiality of the route that has been followed for those documents. So yes, the same integrity standards apply, but that standard requires that we distinguish between documented concern and allegations. Integrity does not mean treating every accusation as fact. It means applying the same fair evidence-based standard to everyone. Question 37 from MP Doran. Through you, Madam Chair, have you ever requested an independent investigation of the conduct of the Minister of E.S.A.? The answer is no, I did not request an independent investigation for the conduct of the Minister of E.S.A. Question 38, Madam Chair, will you commit to submitting all relevant documentations to an independent investigative body as well as Parliament in copy form? That is the normal procedure, members of Parliament, both for the independent investigator and for Parliament. As such, we have submitted documents to Parliament on May the 29th, 2026, and additional documents on June the 9th, 2026. Question 39 from MP Doran. The MP would like to know, since the Prime Minister does not want Minister Brugge in the Council of Ministers, will the party be giving him back his seat if they choose to fire him or he chooses to resign? Madam Chair, through you, the following answer is given. I can expect members of Parliament to know actually how the system works. So the question is, are we going to then retract members from a chair to give it to the members of Parliament? That is not possible, and I will explain you why. In our system, parliamentarians are elected through a parliamentary election, while ministers are appointed, they are not elected. When a member of Parliament accepts appointment as a minister, that member must resign from Parliament and therefore gives up his or her parliamentary chair. That seat then becomes available to the next eligible candidate on the party list in accordance with the electoral process. Once that has happened, the seat is no longer assigned to the person who chose to resign from Parliament to become a minister. Therefore, there is no automatic right for that minister to later request or reclaim that chair. It is important that we all remember that seats are not only tied to individual candidates, but also to the collective vote received by the political party. Most members are elected based on the total number of votes received by the party as a whole, not solely on their individual votes. In this particular case, the issue is not only about a parliamentary seat. The concern also relates, and perhaps mainly relates, to the former minister's own action, the consequences those actions have had for him, for the trust, for the confidence and political cooperation within the party and the coalition. Now we're going over, Madam Chair, to the answers to the questions of MP Jansen-Webster. Hearing all the talks about an open feud back and forth between the Prime Minister and the Minister of E.S.A., the MP wants to ask the Prime Minister how many public letters he himself released or how many press releases he had regarding this matter. The answer is none from my side. I did not release any correspondence to the media, and I didn't write myself any article concerning this matter. Question number 2 from MP Jansen-Webster. How many correspondences did the board of the USM release, and were these letters press releases? How many were actually released on this matter? Answer to this question, Madam Chair, is the board released 2 press statements dispelling the accusations and allegations by the former Minister of ESA, which came after the apparent leak of the letter from the board and the former minister's response. Question number 3 from the Member of Parliament, Mrs. Janssen-Webster, through you, Madam Chair. Since it seems as if the matter was being handled internally, did the Prime Minister, the leader of the USM, actively try to resolve the issues with the Minister of ESA, and when did the Prime Minister start with this? Answer to this question is, of course, since last year, March, attempts were made to address this issue with the former minister. We have had communications with the minister, personal discussions with the minister, meetings with minutes, and also correspondences with the minister. Question number 4, when was the first meeting held with the Minister of ESA on these matters, and how did the board first get involved? The answer to this question, Madam Chair, is as follows. The first meeting was held on March 19, 2026. The board became involved when complaints by Ministry of ESA staff and other stakeholders were made directly to the board. Question number 5 from MP Veronica Webster-Janssen. Was it the Prime Minister who alerted the board? How was the board alerted to these matters? The answer, Madam Chair, to this question is as follows. It was not the Prime Minister. The board became involved when complaints by Ministry of ESA staff and other stakeholders were made directly to the board of the USM. Question number 6. The MP would like the Prime Minister to clarify the Article 3 mentioned with the approving of the doctor, the huisarts, as she said. Can the Prime Minister clarify now that article is relevant, if that article is relevant in this case? The answer is as follows. It is relevant as there is an acute, threatening shortage of GPs for St. Martin, and this article provides an avenue to address this shortage. We have to realize that gradually in the past years, a lot of great medical professionals left the sector of the first line aid for St. Martin. It's common, it's known, it's very great professionals that left due to their age, for example. We have Dr. Datema, a very well-known man in this country, good man, as they say. We have Dr. Chadin left too. Dr. Swanston left too. Dr. van der Waag, Dr. Gums. These are a lot of, Dr. Spencer is not actively anymore a family doctor in this country, a GP in this country. So we have had a lot of doctors that actually, due to aging, having many, many years serving the people of St. Martin, and we did not see an aggressive approach to try to substitute these doctors. So it's important for us to realize that we have an aging group of practitioners, general practitioners in this country. And on the other side, due to that, a lot of doctors go on pension. And on the other side, we do not see an inflow of young blood to help us guarantee the continuity of care for the people of St. Martin. And that is a worrisome situation for the community of St. Martin. It is relevant as there is, I think it's very relevant, as I say, that we make sure that we get enough doctors to help us here in our island. You have to realize that St. Martin is a beautiful island, but it takes a lot for professionals to come and establish on this island. They have to come with their family. They're not accustomed to the school system in St. Martin. They are being paid different than in their own country. So there are a lot of things that they have to consider before they come to a different country that they're not known with, to them to say, okay, I'm coming to come here, establish myself, and actually follow my life here in St. Martin. So it's quite a big challenge to get professionals to work here in St. Martin in the healthcare. By the way, there is a Dr. Daniel. I want to make use of this opportunity to congratulate her. I did that recently also with a press statement. Dr. Daniel is an eye specialist, and she's the first local specialized eye doctor for St. Martin. I'm very happy to be able to share that with all of you. And by this, I want to make use of this opportunity to congratulate our first local ophthalmologist for St. Martin, our first. I see MP Myers hitting very proudly on his table because he feels the pride that we should feel for this occasion. Once more, St. Martin, congratulations with your first eye specialist coming, and hopefully she will come to St. Martin to help us with eye care here in our community. Question number 7, are there any other cases like this on St. Martin? If so, how many and since when? So if the Prime Minister can elaborate on if there are other cases of doctors who do not have the huisarts certification, then what was the reason, or what is the article in the law that supports that? Is that Article 3? Yes, there are other cases of doctors that do not have the huisartsen certification. There is an article in the law that supports this, and that is Article 3 of the National Ordinance regulating the practice of medicine. And by the way, members of Parliament, I have to apologize. In the last meeting, I informed that there were 4 out of 19 doctors without the specialization as a family doctor. It is not, and for that I apologize, it is not 4 out of the 19, but it is 9 out of the 21. So if you're speaking about the specific certification, I said first I thought there were only 4 doctors that have it out of the 19. I was misinformed. It is not 4 out of the 19, it's 9 out of the 21 doctors that have the specialized family medicine certification. This has nothing to do with your qualification. I repeat that, for there is not to be panic. That's not true. It has nothing to do with your qualification as a general practitioner working in the first line of St. Martin. So please, we have great doctors in this country, have been serving us for years, and it's pure an interpretation of actually the definition of what is a GP, what is a family doctor, what is a medical doctor, and I tried in the beginning to give some explanation to that. Question number 8. In regard to the big legislation, the MP would like to ask the Prime Minister to indicate to us what the exact documented wording was to the VSA Minister in what the involvement would be of the legislative lawyer with the big legislation that would be done via the TWO facility. The answer to question number 8, through you, Chair of Parliament, the wording as documented in the co-signed memo to the Council of Ministers signed by myself and the then Minister of VSA is as follows. Thus, we were talking about a document that has been shown with my signature on. That was one for the Secretariat of the Council of Ministers. There is one of the Minister of VSA, and at the end we came to an agreement. We annulled both letters, memos, and we had a third one, and that one was signed by me and co-signed by the Minister of VSA, and with that, that document was ratified and is valuable to move on with. What did it mention? The preparatory work concerning a draft HCPR legislation that has been submitted by the Prime Minister shall be taken into consideration. So the agreement, first agreement that we had on the memo is that the preparatory work since 2017 concerning a draft HCPR, Healthcare Professional Registry legislation that has been submitted by the Prime Minister shall be taken into consideration. That is the first agreement that I had with the Minister of VSA, approved by the Council of Ministers. This draft HCPR legislative framework will serve as a guiding basis in the further execution of the project. So we agreed that the draft HCPR legislative framework will serve as a guiding basis in the further execution of the project. That is how it's documented in that agreement. The individual who prepared the above-mentioned framework will be included in the discussions and deliberations during the execution of said project. So the legislator that has worked on the HCPR will be included in the discussions and deliberations moving forward with the further development of this HCPR. This was agreed upon by both ministers as documented in the signed memo to the Council of Ministers on January 7, 2026, and by the Council of Ministers decision on January the 13th, 2026. These documents were provided also to the Parliament of St. Martin. Now we're going over through you, Mr. Chair, to the questions of Mr. MP Irion. First question is, did the Prime Minister inform the coalition when he heard, saw, or identified these unethical integrity breaches? When did you inform the coalition? We didn't inform at first. This was being handled as an internal matter, as a political party. As mentioned, Mr. Brugge was warned and also advised that in the case these concerns were right, to retract, please, his decisions. Question number 2. From MP Irion, through you, Mr. Chair, the Prime Minister mentioned that based on information provided that the Chief of Staff created the advice and participated and informed the other entities to bid, on what information, who told the Prime Minister that the Chief of Staff created this advice? The answer to this, Mr. Chair, is the following. The board brought it to my attention that the Chief of Staff of the Minister of VSA has created this advice based on the complaints received from concerned VSA ministry staff and stakeholders. Information provided to Parliament dated the 29th of May 2026 included a copy of the advice signed by the Chief of Staff awarding the contract to the company of her husband. Within that advice, there is an email correspondence which clearly shows that the Chief of Staff of the Minister of VSA invited companies, including the company of her husband, to bid on the contract. Question number 3 from MP Irion. Did the Prime Minister check or verify with the ministry itself, so from the SG, Financial Controller, Department Heads, whoever, NRPB, if they were all in agreement with how this went? Did they indicate to you or to P&O, to anyone that falls under you, that they have concerns with how things went? Answer to this question is, I would like to refer to, of course, the advices of the Department of Legal Affairs, which has also been provided to Parliament. So I have given some documents to Parliament, confidential route. You can please read them, and then it will be clear about this answer. Question number 4, the Prime Minister mentioned there was a contract of 50,000 or less and those payments were made. Were those payments made based on the contract? The answer, MP Irion, is based on the information received, which I have started with Parliament, which I have shared with Parliament, there was a contract for an amount of 48,510. Because the contract amount was below the 50,000 threshold, it did not come to the Council of Ministers for approval. However, the payments made to the company ultimately exceeded, though, the 50,000. That raises the question of the legal and administrative basis for those additional payments. Those payments, therefore, cannot be based on that same contract. No addendum to the contract was received by me, nor have I seen documentation showing that the required procedure was followed for an additional payment. It is clear that this matter raised serious questions. Question number 5. If the concern is that ministers giving contracts to family members, which has happened with other ministers in your council currently, and payments continue to be made past the contract, then would the Prime Minister then say that they also have to go for integrity issues? Answer to this is, I am completely aware that no contracts have been given to family members in the cabinet of the Prime Minister. So for AZ, I am not aware that there is any contract that has been given. I'm speaking about my cabinet of Azet. Concerning the other minister's cabinet, the information has been requested and I will send the answer in writing. So I have checked in my own cabinet. I'm not aware of any contract given to family members, and I posted and I put that also in discussion and questioning for the other ministers. And the moment I have the answer, I will send it to Parliament. Question number 6, is the Prime Minister aware? And if not, I would like him to ask the Council of Ministers if any ministers that has given a contract, an agreement as SLA to anybody to work in their cabinet and continue to receive payments past the 50,000. Answer to this question, Mr. Chair, I refer to previous answer. No contracts, agreements, or SLAs have been given to anybody to work in my cabinet. Concerning the other ministers' cabinet, the information has been requested, and I will send it to the members of Parliament. Is there anything I have to know? No, it's good. Yeah. Do you agree then that they should be accused or labeled as integrity breaches, just like you are accusing the current Minister of ESA? Of course, if that is the case, something is wrong, but I have to weigh the answer, and I will share it with you. Question number 8. Does the Prime Minister believe that an integrity breach matters on how heavy it is? For example, do you believe that if an item is being paid without a legal basis, that is also an unethical situation? And do you agree that you are breaking then also the integrity? So if a minister is making a payment and there is no line item in the budget, there is not even a budget, do you agree that this is illegal? And if this is lack of integrity? The answer to this question is as follows. A breach of integrity is a breach of integrity. As for the example given by the MP, I'm aware that in the past, vacation allowance was also paid before the national ordinance was accepted in Parliament. So in the past, there were moments that payments were made anticipating the approval of the budget in Parliament. Is this integrity or disintegrity? There is a form also that everybody understands why sometimes payments has to be made for the common interest of the country. Good. There is now, yes, that is, in January 2025 or late February did the Prime Minister bring the matter officially to the Council of Ministers? The answer is no, I didn't bring anything to the Council of Ministers. Question number 9, did the Prime Minister formally address the Minister of VSA and allow him to formally respond to him in January or February? Answer is, the former Minister of VSA was absolutely addressed. Question number 10 from MP Irion, through you, Mr. Chair. When the Prime Minister saw or heard or identified any integrity breaches, did the Prime Minister go to the Integrity Chamber? Did the Prime Minister go to the Ombudsman, or to the Audit Chamber, or to the Public Prosecutor? Answer to this question is the following, through you, Mr. Chair. I refer to my previous answers to start with. As mentioned, we try to solve this matter internally by warning the Minister about the concerns, and we strongly advised him to retract any wrong actions he may have committed to and to refrain from repeating them. When confronted, the then Minister requested an investigation from the Integrity Chamber. It's okay, no problem, as I said.
One moment, Mr. Prime Minister.
Yep.
I see MP Irion would like the floor, but I think I know what it's pertaining to. It's one of the questions that he posed, pertaining to a conflict within cabinet and contracts with family. I know you answered based on your cabinet, and you said that you needed, or you didn't get all the information from the other ministers as yet.
Yeah.
So I would propose then, if you receive them when we go to clarification round, that we can then propose that you answer those. Yeah.
Okay.
Thank you.
Okay, the question I had was question number 11, I thought, or I did that already. Did the Prime Minister inform the Chair of Parliament of these integrity breaches in January or February? The answer is no, that is not the case. Question number 12, can the Prime Minister explain how a civil servant in his own cabinet, because his Chief of Staff is still a civil servant, was appointed to the Saba Bank? Oh yeah, that is also something that regularly pops up in Parliament about some person, a civil servant that has been appointed to the Saba Bank in the board of the Saba Bank. I think with this answer then we can lay this to rest too. The Saba Bank NV had a vacancy for the position representing the public entity of Saba. Thus, the person in question fills that vacancy for the public entity of Saba after having received the necessary approvals of the Council of Ministers of St. Martin, the Council of Ministers of Curaçao, the Executive Council of St. Eustatius, and most importantly, the Executive Council of Saba, for which the person represents. So that appointment of a board member on the Saba Bank Resources is a representation by the public entity Saba. Question number 13. Can the Prime Minister also provide a copy based on the law with a request and permission from the Minister of Education? Based on the law, you need a request, you need a permission from the Minister of Education, Culture, Youth and Sport to be able to be appointed to the board. The answer to this question is through you, Mr. Chair. The approval was based on a decision of the Council of Ministers, in which also the Minister of Education, Culture, Youth and Sport is represented. Question number 14, was a mediator ever suggested or acted upon to resolve this matter with the Minister? The answer is no, no mediator was suggested. Coming now to the answer to the questions of MP Myers. The first question, through you, Mr. Chair, how does the Prime Minister define integrity in public office, and what specific behaviors best show in it on a day-to-day basis? So how does the Prime Minister define integrity in public office, and what specific behaviors best show it in your day-to-day role as Prime Minister? The answer is as follows. Mr. Chair, integrity in public office means acting with honesty, accountability, fairness, discipline, and respect for the law, especially when discussions are difficult or politically uncomfortable. For me, integrity is not simply a political word. Before entering public office, I served also in this country, as you all know, as a surgeon here in St. Martin. That profession teaches you that responsibility must be taken seriously, that trust must never be taken for granted, and that every decision must be made with care. Coming to question number 2 from MP Myers. What concrete steps has your government taken to strengthen public sector transparency since you have taken office as Prime Minister? Answer to this is the following. In daily operations, I encourage the Ministry to ensure that we are always referring to legislation to start with, to provide the foundation of policy and decision-making, always referring back to the legislation. Also, it must be noted that strengthening transparency requires systems, it requires procedures and proper documentation and better access to reliable information for decision-making. within the Ministry of Gender Affairs. I can point, of course, to a few examples, but I don't think at this particular moment it's necessary to exactly elucidate what I have just stated. Question number 3 from MP Myers. How does your government protect whistleblowers who report misconduct in public? So the question is, how does your government protect whistleblowers who report misconduct in public? The answer to this is the LMA, de Landsverordening Materieel Ambtenarenrecht, is the applicable legal framework for civil servants that report misconduct, including suspected breaches of integrity. Civil servants are protected by Article 85 of the LMA, de Landsverordening Materieel Ambtenarenrecht. De ambtenaren, and the Article 85 of the LMA says the following. I can do it in Dutch, but also in English. It's the civil servant who, in compliance with the provisions laid down by our pursuant to this national ordinance, has reported a suspected breach of integrity. If he reports a suspected breach of integrity, shall in no way be prejudiced in this position as a result of the reporting, insofar as the act in good faith and derives no personal gain from the breach of the reporting thereof. Article 84 specifies who a civil servant should report a suspected breach of integrity, to which is the responsible department head or next higher ranked in supervisory. It should be further noted that the Integrity Chamber has issued an advice in 2025 on the need for a whistle-blowing policy for the government of St. Martin. This advice will be taken along in the development of a comprehensive integrity policy and the appointment of confidential advisors as foreseen in Article 82, Article 83 of the LMA. Mr. Chair, I hope that I could have given sufficient answer to all the questions that has been posed in this matter, and I hope sincerely that some clarification could have been given, and I am of course willing to give further answer if any clarification is necessary. Madam Chair, Mr. Chair, members of Parliament, thank you for the opportunity that you gave me to come and give answer to your questions. Thank you very much.
Thank you, Prime Minister. That brings us to the end of the answering of the first round. We now go over to clarification. No, to answering of the first round of questions, correct. So now go over to clarifications. So to which member do I give the floor for clarifications? I see MP Ottley. MP Ottley, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, as I listen to the Honorable Prime Minister with his answers, again, the last time I said it, some people got in their feelings. The mic is feedback. Okay, some people got in their feelings, but I'm going to say it again. The Prime Minister, again, is lying to the public, creating a notion. Mr. Chairman, when I look at the motion signed by my person in 2021 for the doctor that we spoke about, it clearly states, and I read, because it was mentioned, to approve the establishment request submitted by St. Martin Medical Center for the doctor to practice as a medical doctor in the capacity of a house officer at SMMC. House officer, under the supervision of other doctors in the building. The Honorable Prime Minister speaks of the 2022 extension signed by my person. We asked for it. I will go ahead and read it for the members of Parliament. It says, to take note of the extension request submitted on December 30th, 2021 by the St. Martin Medical Center on behalf of the doctor, house officer to continue practicing as a house officer from February 28, 2022 until February 27, 2023. House officer. So, my question and clarification, what did you extend? Through you, Mr. Chairman. Because when I read what the Honorable Prime Minister extended and told in the memo was to practice independently as a medical doctor in St. Martin. That is nowhere, no how, what the extension of 2022 said. So I would like clarity, since we're going back to 2022, what was extended? Because in 2022, it clearly says house officer. Madam Chair, I have a lot of other clarifications, but I think round two will be very interesting, Madam Chair. So I'll save that so we can get to round two as quick as possible, Madam Chair.
Thank you, MP Ottley, for those clarification questions. We continue with the clarification round, and I now give the floor to MP Jansen-Webster for your clarifications. MP, you have the floor.
Thank you, Madam Chair Lady, and good morning, good afternoon already to the Prime Minister and his support staff, and to our listening audience, and to the colleagues on the floor of Parliament today. I just had one clarification, Madam Chair, to my question when I asked when was the first time that the Prime Minister met with the former Minister of VSA, and the Prime Minister answered March 2026, which was, I think, about 3 months ago. So if the Prime Minister can clarify that date. Thank you.
Thank you, MP Jansen-Webster. The next MP for clarifications is MP York. MP York, you have the floor.
Thank you, Madam Chair. Good afternoon to yourself. Good afternoon to the Prime Minister and support staff. Madam Chair, I just have a few questions for clarification. For you, Madam Chair, Prime Minister, can you, I'm getting a lot of feedback here. Okay, thank you. Can you explain or clarify what is a house officer? What is a house officer? Is a house officer GP? Is a house, maybe another term for it? What is a house officer? What are that the people of St. Martin know as family physicians? So think about the Dr. Arundels, the Dr. Bosses, etc. What are they? What is the exact term or function or qualification? What are they? Are they regular GPs? Are they something else? What are they? Because I feel that we're going around in circles when it comes to definitions, and I would like the official definition of the Prime Minister on these questions. Bear in mind, Prime Minister, these doctors are watching as well, I think. So, moving on, Madam Chair, the Prime Minister referenced that meetings like this are a waste of time, topics like these, that he questions the relevancy, and even what came out of the prior meeting on a media outlet he referenced as political rhetoric. I would like the Prime Minister to clarify exactly what he means by that. I don't want to take his words out of context, so if the Prime Minister can explain exactly what he means by that. Also, for the deviation from the use of Article 3, the exemption, Prime Minister said that he had adequate reason to deviate. Can the Prime Minister, for the record, clarify what the adequate reason was? And the person in question, can the Prime Minister, via you, Madam Chair, clarify the exact license that this individual has to function on St. Martin, to operate on St. Martin? So, in one advice they spoke on house officer, in the next advice they spoke on house arts. Can the Prime Minister clarify the exact license given to this individual recently, a couple of years ago, to function on the island? Can he clarify the exact function that clarify? not qualification, but credential given to this person to operate on St. Martin. When I say operate, I don't mean operating room. And that will be it as it pertains to my clarifications, Madam Chair. Thank you.
Thank you, MP York, and I just wish to remind, and also the Prime Minister, on the document with respect to that explanation that would be sent to Parliament, because I think that will help a lot as well. But we continue with clarifications now by the members, and I give MP Doran the floor.
Thank you, Madam Chair. Madam Chair, you took the words out of my mouth, because with that written clarifications, that would clear up a lot of clarifications, but I'm afraid that if I don't ask the clarifications, it would not be taken up. So I will give the Prime Minister, in this case, the benefit of the doubt and save those points for the second round if need be, but hopefully before the second round we can receive this clarification to put a lot of things to rest. I know for a fact, through you, Madam Chair, that in this realm that we are with government, there's English and Dutch and a lot of translation taking place. So you have a general practitioner, you have a medical officer, MD, and honestly, it was a good explanation in terms of wordplay and the dictionary, but we need clarification because, Madam Chair, I'm going to say the following. When I mentioned that the Prime Minister personally knew the individual, it was not my words. The Prime Minister mentioned it here on the floor of Parliament. So now for my words to be twisted and turned as if I am creating an issue where there is none, I hope there is no issue, Madam Chair, and I really hope that the doctor is qualified for what work is carried out. I really hope that, sincerely, because then that would put a lot of people gerustgesteld, as they would say. Because the Prime Minister mentioned that 4 out of 19 have the proper certification. Today we hear 9 out of 21. So therefore, this special document will definitely help us, and I will go back to my constituents and explain this and this is the case. Because there's a lot of doubt in minds right here, right now, and the doubt was created based on the statements made by the Prime Minister, not the opposition, Madam Chair. Because if you ask me, I would think that everybody has all the right documents when they work in. I never knew there were certain loopholes that certain people could deviate. Through you, Madam Chair. Madam Chair, through you, I would like to go to the point where the Prime Minister, because I'm skipping all the clarifications, hoping to get his document. I'll go to the point where the Prime Minister mentioned the liability is on the doctor in question. So God forbid something goes wrong in a medical situation where the doctor that does not have the proper certification is at play or at fault, the liability goes on the doctor. But I'd like to ask the Prime Minister to please clarify, because if the doctor doesn't have the proper qualifications and the government allow them to practice, how is there no liability for the government that allowed them to practice, knowing that they did not have the proper qualifications or certifications? Because similarly, that would be like a police officer stopping somebody that is 16 years old on the road, for example. They know they don't have a license. Continue. Who does the liability fall on if that police officer is picked up on camera doing that? The police officer would also have to carry liability, Madam Chair. So through you, I would like some clarity on that point. Madam Chair, I heard the Prime Minister mention about due process and the due process and things having to follow the proper procedures. But Madam Chair, if the due process from the end of the Prime Minister, if it was so clear about the violations of the former Minister Brugge, why wasn't the motion focused on that? Because the motion that was brought forward by the URSM party mentioned that the minister did no wrongdoing personally or professionally. But on the radio, the Prime Minister is talking about wrongdoing. He's mentioning wrongdoing right now through you, Madam Chair. So therefore, I would like to know through you, from the Prime Minister, where was the due process there? Are we doing convenient due process? Madam Chair, even in the statement just now through you to the Prime Minister mentioned there are or could have been potential conflicts of interest, possible conflicts of interest. So the Prime Minister isn't even sure. Yet a verdict was cast based on the support and the extra validation from the Prime Minister. Madam Chair, through you, I would like to ask the Prime Minister, or I would like to make a statement then. Of course, Madam Chair, I am aware of the process when you're elected and when you're appointed, how you could give up your seat. how that goes. But I'd like to make one thing clear, because I heard the Prime Minister made a bold statement that he expects that members of Parliament would know the process. I'm very much familiar with the process, Madam Chair, and the Constitution, because I signed off and gave my seat several times. But I'd like to make one thing clear. I don't know if the Prime Minister is carrying out his agenda and continually saying that...
MP, remember this is clarifications,
Yeah,
huh?
no, it's very clear what I'm coming to based on a statement from the Prime Minister, Madam Chair. Because the Prime Minister mentioned that MPs should know the process in giving back the seat. That was one of the questions that I posed. So I would like to clarify and also ask for clarification from the Prime Minister based on the following. I'm very much familiar with the process when you give up your seat. However, my question was simple. Would the party consider giving back the seat to the minister once they get rid of him because they no longer see him fit as a minister? For the Prime Minister to say, Madam Chair, that that is not how it works and so forth, it was done before because Theo Heiliger got back his seat from Dr. Ruth Douglas. So therefore, I want to be clear, because the public is also asking for clarity on these points. The good gentleman was duly elected. You no longer enjoy the confidence as minister. Would the party consider giving back the seat? A yes or no question. Very simple, and I hope that I can get some clarity on that. And the fact that the Prime Minister continues to mention on every public platform, every time there's opportunity, that only 30% or 40% of the people of St. Martin are educated, I think that maybe that is the reason why he continues to make certain statements thinking that we ain't gonna understand. And I would like some clarity on that. Thank you, Madam Chair, for the opportunity.
Thank you, MP Duran. The next MP to speak for clarifications or to ask clarifications is MP Irian. MP Irian, you have the floor.
Thank you, Madam Chair. Thank you, Madam Chair. The Prime Minister mentioned that he has no one from the board that has a contract with him in his cabinet. Madam Chair, through you, I'd like to ask if your Chief of Staff is not on the board of USM, and if your Chief of Staff doesn't have a contract with the Prime Minister. Because it's a very simple question. I think it was posed by either MP Duran or MP Ottley. Does anyone that's part of the board of USM has a contract with you? And I think the answer is yes, and you shouldn't be ashamed about it. It's a fact. Madam Chair, the Prime Minister also, I realize that whenever the Prime Minister comes, it's always like a game and to get answers from him. But I can understand why, because like he mentioned inside of here, and he mentioned on the radio that he thinks Parliament is a waste of time, and I think that could easily be resolved. He also mentioned that he has a lot of stress, and again, I think that could also be easily resolved. I asked the Prime Minister if he's aware or if he knows of any other, including himself, minister that has accepted or accepting any a consultant or entity that passed the 50,000 guilders, and if you hold them equally accountable. So if you find out that in the last 2 years, members of your council of ministers have, without a contract, accepted or made payments to individuals beyond the 50,000 guilders, will you also hold them equally accountable? And Madam Chair, the Prime Minister, again, I think what MP Duran said just now, I didn't think about it that way, but now I definitely agree with him. I believe that he believes that he can just fool everybody. And because maybe the public does not have the documents in hand, that I'll just word vomit and say different things and just continue to talk about how good he is and how hard he's working, that the people would not understand. Madam Chair, it's very clear. And he also goes back and tries to throw blame on the former minister. Says, I just, today and on radio, the Prime Minister mentioned, I just extended what the former minister did, MP Ottley. It was already there. I just extended it. Okay, and let's see if that's true. So in documentations, the Prime Minister also said that last time he was here, he said there's only 4 persons working that have the qualifications. And it was very interesting because after the damage is done with Brooke, he could come back and say he misspoke, he misspoke, he misspoke. And I wonder how much other things he misspoke about. Because after...
Clarification, MP?
Yes, I'm clarifying, Madam Chair, and that's why I also presented my documents to ask what's the clarification. 'Cause I'm allowed to bring my statement first. After the Prime Minister mentioned about the young lady being a family doctor, I would like to ask the Madam Chair to the Prime Minister, did the doctor ask to be an independent physician? So in her request, did she ask to work independently? Because, and did the council advise against this and say she cannot work independently? And Madam Chair, I'd like to ask the Prime Minister, is a house officer usually a junior doctor? Is a house officer, because that's what the former minister signed off on. The former minister initially signed off on hiring the individual. Let me clarify. Madam Chair, the Prime Minister mentioned that he did exactly what the former minister did. So I want to clarify. Did the former minister hire the individual to work in the medical center, ER, as a house officer? Through you, Madam Chair, the Prime Minister then said that he gave an extension. So I asked the question then, did the former Minister of VSR give an extension to the house officer to work in a medical center under ER? And not to work as a general practitioner? Because then, Madam Chair, it would be the Prime Minister isn't speaking anymore. He's lying. Madam Chair, you would like to ask the Prime Minister, did the council say that the individual at hand cannot work independently? The Prime Minister, in his own words, Madam Chair, said that the current physician has 20 years of experience but does not have the qualifications, and I understand the predicament, but it will still remain that they don't have the qualifications. So now you have an unsupervised person being unsupervised by the right person. I would like the Prime Minister to clarify that. And I think I'll leave my clarification for him, Madam Chair, and I'll ask my other questions in the second round. Thank you.
Thank you, MP Irian. Are there any other requests for clarification? I see MP Duran. I'll get to him, but I just want to know if there are any others, and then we go back, if necessary, to, amongst others, MP Duran. At this time, I see MP Labega, and I give the floor for clarification to MP Labega. MP Labega?
Thank you, Madam Chair. Madam Chair, to the Prime Minister, I would like to know if there's any representatives of St. Martin on the Sabre Bank. If the Sabre Bank has a representative from St. Martin. Thank you. That'll be all, Madam Chair.
Thank you, MP Labega. And now I continue and I give the floor again to MP Duran and then again to MP York. MP Duran, you have the floor.
Thank you for your indulgence, Madam Chair. It slipped me to mention one of these points what I sought clarification for, because again, Madam Chair, I believe that the public not having all the relevant information, sometimes messages can be confusing. So thank you for your indulgence. I'll go into the following. I'll just breeze through this advice. Advice on the facts. On the 20th of May, 2024, so this is about 2 weeks after this government swearing, through you, Madam Chair, the Public Health Council, herein referred to as the council, were asked for advice. I'll just breeze through it. The aforementioned request advice was addressed against the following relevant legislation: Articles 3, 6, and 14 of the National Ordinance on Public Health, Article 2 and 3 of the National Ordinance regulating the practice of medicine, Article 3, 4, and 5, and 7 of the National Ordinance on Healthcare Institutions, as well as the KZ Ordinance. Consideration of the Public Health Council. The chairman and all the attendant members reviewed the submitted request. The council deliberated on the matter on June 10th, 2024. So 2 years ago today, actually. What a coincidence. Hereby issues the following advice. The council carefully examined the application of the healthcare institution license submitted by the individual and has reached the following conclusion. From from the file presented to the council, only the following qualifications were evident: a university bachelor's degree in medicine, geneeskunde, university master's degree in medicine, also geneeskunde. Furthermore, it appears that from the big register, the individual is a registered physician. However, in order to function as a general practitioner, family physician, one must complete the specialization in general practice medicine. This individual has not completed the general practitioner training program. As a result, cannot function as an independent general practitioner. In addition, the individual has insufficient work experience, which constitutes further concern for the council. Therefore, the council considered it irresponsible to allow the individual to practice independently as a general practitioner without the special prerequisites as a professional individual would require. Madam Chair, we've been talking about this for weeks now. We even heard some new ways of spinning the truth today. And I just want to say two feedbacks through you to the Prime Minister from some colleagues of yours that are watching this meeting. Why is he being dishonest? The other one mentioned, sad to see the PM digging a deeper hole for himself. A general practitioner is the same as a family physician. This is pure wordplay. The doctor in question is just what you call a junior doctor, only allowed to work in a hospital under specialized supervision and not in a GP medical clinic. Thank you very much, Madam Chair.
Thank you, MP Duran. Was there a question to the Prime Minister on what you expounded on? And the question is?
I started off by saying, Madam Chair, I would like for the Prime Minister to clarify these points. And now that he knows what we know, I hope that the truth could come out this time. Thank you.
Thank you, MP Duran. The next MP is MP York. Members, I remind you that we're still in clarifications, so please try to get to the point of your clarification rapidly. MP York.
Thank you, Madam Chair. Madam Chair, I forgot to mention one thing. As I discussed earlier, I asked in the first round the Prime Minister 41 questions. The Prime Minister only answered 7. So, with saying that, and with attention on time, I filtered through those that he didn't answer, and I came down to 4 that I really would like to have answered during this session. So I don't know if you would like me to read them out or hand them over to the Prime Minister, but I would appreciate if these questions still be answered.
Thank you, MP York. Indeed, we had discussed that before, and I had indicated when you indicated how many questions were still outstanding that we'll pass us on to the Prime Minister. You have broken them down to 4, and I would suggest that as clarification, you ask these questions again, the 4 that you want to bring forward, which were not answered. I'll allow you to do that now, MP. Thank
you, Madam Chair. Okay, they go as follows. If skipping advice from the Council of Advice if skipping advices period was previously defended by other ministers as merely advisory, why is it now treated as a serious integrity issue? If one minister is being held accountable for these actions, will every minister moving forward who engage in similar conduct be held to the same standard? If integrity is the issue, will the same rules be applied to all ministers and not only when it's politically convenient? And lastly, Madam Chair, the question that a lot of people have been asking recently, if the Prime Minister cares so much about healthcare matters and legislation on the VSR, why did he not become the Minister of VSR when he had the opportunity for the second time? Thank you, Madam Chair.
Thank you, MP York. The next MP to speak is MP Roseberg. MP Roseberg, you have the floor for clarifications.
Thank you, Chair Lady. Blessed afternoon to the Prime Minister and his support staff. Also a blessed afternoon to my honorable colleagues present here today and to the people of St. Martin tuned in to whichever social media form. Madam Chair, through you, just to clarify and also to make it clear that this clarification is not for the sake of loyalty, as I don't operate as such, but for the case of transparency and clarifying the matter. It was mentioned here today on the floor of Parliament, I think it was a question of MP Irion, that, and I'm not sure if I understood it correctly or heard it correctly, maybe the Prime Minister misspoke or forgot through you, Madam Chair, that no mediation was started. Was that the answer, or did I hear it correctly? that no mediation was suggested and or requested, because I can recall that among myself, and I don't want to cry over spilled milk, it is already a station passé, but seeing that we're talking about the matter here on the floor of Parliament, I do believe it's important to have that clarified, because I can recall that I was one of the persons that requested and suggested mediation before going to the final stage. And I'm just mentioning this here today because that question was asked, and I do believe it's important to be transparent in that sense, because I also mentioned it on the radio, and I don't want to come over as someone that is not speaking the truth. So maybe it was forgotten, or I didn't hear the question correctly, or the answer to the question correctly. So if that can be clarified, thank you.
Thank you, MP Roseberg. I would now give the floor to MP Lewis.
Madam Chair, thank you for the opportunity. Madam Chair, with regards to the advice for the doctor in question, okay, basically the advice from the service denying the request for the extension, I would like to know, Madam Chair, how did the Prime Minister got whiff of it? How did he got his hands on it? Did he ask, I need him to clarify, did he ask the cabinet to give him that? Because you can only know about this if it's within the minister's queue, and that was for the Minister of VSA at the time. And this advice apparently was on the table of the former Minister of VSA before Minister Brooke, which is Veronica Janssen. And I would like to know, how did it reach in the Prime Minister's hand to sign? So I would like to know, how come the former Minister of VSA, Veronica Janssen, did not touch that advice at that particular time? Then Minister Brooke inherited it. And then the Prime Minister himself, as acting Minister of VSA, signed it. So Madam Chair, I would like him to clarify how did he, as the Prime Minister, as acting Minister of VSA, two ministers before him, did not sign that document, but he got it. Thank you, Madam Chair.
Thank you, MP Lewis. I now give the floor one more time to MP Ottley. MP Ottley?
Thank you, Madam Chair. Madam Chair, that was exactly my question. We're speaking about MP Ottley, but there was two ministers before the Prime Minister in the space of MP Ottley, and my question was indeed that. Thank you, my colleague, MP Lewis. Why wasn't it signed by the two previous ministers that came before the Prime Minister and after me? Thank you, Madam Chair.
Thank you, MP Ottley. MP Iran, I see you have, but please make it short and a clarification, and then we're going to close off the clarification round and hear how we proceed. MP Iran, you have the floor.
Thank you, Madam Chair. Madam Chair, I think we have to establish what the clarification is in the next meeting, so we can all be very consistent. Madam Chair, the Prime Minister mentioned his deviations and why he thought it was important to deviate, et cetera, et cetera. So my question to the Prime Minister is, we have a lot of local St. Martiners that studied abroad, but they don't fall in the big registration. Is it possible then that you as Prime Minister could still sign, deviate so that they are allowed to work at home? Because I know that you know a lot of them. So if you're going to do it for this individual, why can't you do it across the board? And why haven't you done it then? Thank you.
Thank you, MP Iran. Members of Parliament, we have come to the end of the clarification questions. What we're going to do now, I'm going to adjourn for half an hour. That half an hour is more of a lunch adjournment, and then we come back at 2 p.m., so a little more than half an hour, and then we will hear about the continuation, which now would include which would be the Prime Minister answering the clarification. But first, so we come back at 2 o'clock. In the meantime, I would have spoken to the Prime Minister about the responses to the clarifications, and at 2, it will be indicated how we proceed further with the meeting. So this meeting right now is adjourned until 2 p.m. Meeting adjourned. Members of Parliament, ladies and gentlemen, we now resume this public meeting of Parliament in which, based on the agenda point and the request of the requesters of the meeting, the Prime Minister has been present, responded to questions posed by members in the first round, and following that, clarifications were requested from the Prime Minister based on the matters brought forward by the Prime Minister. And then we had an adjournment, and the Prime Minister is now going to indicate one. Are there any clarifications that can be given at this time based on what the members ask? And then secondly, we would look at a continuation of this meeting based on the answers to the clarifications and the continuations in the second round of this meeting. So at this time, I ask the Prime Minister to take the floor and address the matter of the responding to questions by members of Parliament. Prime Minister, you have the floor.
Thank you, Madam Chair. Madam Chair, a lot of clarification has been asked to me. I estimated it's almost about 32 clarifications. Obviously, I didn't have enough time for all of them, but there are a few that I will want to make use of this opportunity to, in the meantime, give some clarification on, and I will start with those that I can immediately give a reaction on. To MP York. At the same moment, MP York asked if I can explain the definition of a house officer. What is that now, a house officer? A house officer is a medical doctor that has finalized his education, academic university formation as a doctor. And at that particular moment, you get your, you call it in Dutch, your bul, they call it, or you call it your diploma, your certificate, acknowledging that you are qualified as a doctor. And at that moment, you say, you know what, I feel myself, I don't know exactly which direction I'm going yet, if I'm going to specialize and what specialization I'm going to do. And there is a system, especially in the Dutch system, it's very known, that they call the person, then that person can apply and become a house officer. And the house officer is most of the time young doctors. I don't know if the term junior doctor is a correct name for that, because otherwise you will have a senior doctor too. So it's actually house doctor is the right definition. And for example, by the Department of Surgery where I worked, I'm a trained surgeon that after my basic education of 6 years, I did another 6 years of specialization, making it in total 12 years before I started operating people. The ones that did the first 12 years can apply to become a house officer, and a doctor like that comes to the surgical department, gets work and a function and a position at the surgical ward, where the patients are admitted, and she is then, or he is then in charge with the daily operation of the ward. So for example, if you are a house officer for surgery, you are constantly on the Department of Surgery. You're going to, for example, if I have to admit a patient for operation tomorrow, the patient comes to the ward, and the first doctor that is going to attend to that patient that is going to be operated tomorrow is the house officer. She's going to do the admission. She's going to make a checklist of the medical history. She's going to check on allergies. She's going to make sure that all medication that the patient has to get before surgery is given, and those follow up after surgery. She's going to do the daily visits on the ward. In the morning, most of the time, they do it with the specialist. Like in this case, the house officer will do it in the morning with me as a surgeon. And in the afternoon, most of the time, the house officer does a second round before sunset, before he or she goes home, and make sure that the patient is okay. So they are actually responsible and actually committed to the continuation of the functioning of all patients on the ward. It can be that a patient is admitted through the emergency room, We have our house officer and the surgical ward. They call me, and then I see the patient and decide that I have to admit the patient. I can do two things. I can arrange everything and admit the patient. Then it goes to the ward, and then the house officer seats the patient there again. Or if I'm very busy in the operating room, being on call, being called to the emergency room, I can please ask my house officer to go see the patient in the meantime in the emergency room, admit the patient in the meantime. All that is being done in good collaboration and communication, and later on I can see the patient again with the house officer. Actually, the house officer is not a specialist, but an extension arm of the specialist for the operation of the patients that falls under the specialization that comes to that ward. That is actually the definition of a house officer. That's one. Continuing to another question that I would give answer to is MP Duran asked, will the party consider giving back the seat? The answer is, the arrangement is that the party will not consider giving back the seat. Once the minister that had the opportunity to become a member of parliament decides that he is not going to accept his seat, he is going to move forward with becoming a minister, in that case, and if something happens, he wants to come back, the deal is that once you leave the seat, you're not going to come back. Madam Chair?
Prime Minister, thank you so far, and before you continue, I give MP York the floor for an interruption. MP York.
Thank you, Madam Chair, and I thank the Prime Minister for his answer to my question. However, I appreciate the answer, but it wasn't really the question that I posed, so I just wanted to clarify one thing. I asked not exactly the function of the house officer, but I asked what is the exact legal qualification, what are they? Are they GPs, are they junior doctors, etc.? And also, for what we know as a house physician, so basically, for example, Dr. Boss, Dr. Arundel, Dr. Connell, what are they? Are they GPs? Are they, what was the exact medical legal qualification from house officer to the house physicians? Thank you.
Thank you, MP York. Prime Minister, if you can respond to that interruption and then continue with the answers that you can give. Prime Minister.
It's quite complicated to have a good understanding of all of them. The qualification to become a house officer, the only qualification that you need is that you have to have a finalized medical, academic, university education. That's it. So I go to a university in Amsterdam. I'm going to study what is in Dutch geneeskunde. It's 6 years. I do my stage at the end. In that educational phase, then you are a co-assistant. Once you finish co-assistant, you go back and you say, okay, I'm finished. You made it clear that you understand, you did your exams, you get a diploma. At that moment, you are a doctor. And then if you want to become a house doctor, the requirements to become a house officer is the only thing you require is a diploma that you finalize the basic medical education. Concerning the other definitions, as I agreed with Madam Chair, I will send a whole description for us to understand the definitions. The house officer is not a general practitioner. The house officer is not a family doctor. Pardon? Yeah, I'm going to send you a definition to better understand all the subclassifications of the definition. What is now a family doctor? What is actually a house doctor? What is a general practitioner? And additionally, I just explained the one because I thought you wanted some observation on the house. Pardon? No, but I will describe it because I'm trying already a while to, and I'm still getting the questions, so that perhaps maybe I have to go a little more in details for everybody to have a good understanding.
Members, we are in a public meeting and the rules are a little more stringent in terms of the interaction. But so Prime Minister, yes, you have established that we will get this paper and on the basis of that paper, seeing everything in writing, whether there are more questions from members, that can always take place. But at least we'll get that overview to make it clearer in all our minds including my own, what we're talking about. So, Prime Minister, you may continue.
Further, Madam Chair, I just started just now with one of the questions of MP Duran concerning will the party consider giving back the seat. I gave an explanation on that one. Another one that I would like to make a statement on is actually a statement also of MP Duran is about 30% of our society is not educated. I never said that in different interviews that I had. By the way, the 30% is incorrect. I always have stated 42% of our community does not have a finalized secondary school education. That's something else. This does not mean that the people are uneducated. That's something else. What I state is that 42% of our populace does not have a finalized secondary school education. So the statement that you made just now that I said 30% of the people of St. Martin are not educated, that is not correct. What is correct is that 42% of the people does not have a finalized secondary school education. That is a big difference between saying somebody is uneducated and somebody that does not have a technical enjoyed education. That are two different things. Further, I had another answer from MP Irion. Yes, indeed, MP Irion. I apologized for the statement that I made at 4 of the 19. I was informed first by the family doctors, GPs, that it was 4 out of 19. And then afterward, I had a second conversation for them in which they apologized for the information. And the correct answer is that 9 out of the 21 doctors working in the first line of our healthcare system do have the family medicine certification. So it's good for you to know that 9 of the 21 have the family medical certification. And something that touched my heart that the member of parliament said, and really, man, it touched my heart in a fantastic way, is we have so many locals that enjoyed a medical education, and with our system, they are not getting the opportunity to come back home to help their own people. And I recognized your concern in that, and that is also that I recognize, and that is the reason that I'm working so hard on this healthcare professional registry, because it's going to bring a lot of clarification about the credentials necessary to work in our country. And as long as we do not straight up this healthcare professional registry for St. Martin, we are going to be continued hypnotized by this only big registration that people think that is the only way for a doctor to work in St. Martin. And as I stated, for example, we send our patients to Colombia. We have great neurosurgeons. They are doing very complicated brain tumor surgery for us. And if we ask those professors from Colombia to come to St. Martin to operate our people, you're going to see that they're going to say these doctors are not qualified and thus will not get the legal permission for them to execute, while it's the same doctor that operates our patient, but just depending on which part of the world he stands to do the surgery, you're going to get a total different opinion about the licensing of this doctor and the qualification, because here they say, now this doctor can do the surgery, and in Colombia is a very remunerated man that can do the surgery. And that's why, MP Irion, I'm so happy that I have your understanding and your empathy for the dishonesty that we have in this moment with the regulations that we are adhering to in St. Martin. So I'm very happy that you think that way as I think. Coming back to MP Labega, MP Labega asked if there are any St. Martiners being represented on the Sabre Bank, because we spoke about representation of the Sabre Bank as a representative from Sabre. That was the person that we were discussing on the floor. And then MP Labega asked, do we have now representatives representing St. Martin in the Sabre Bank Resources NV? And that is the case. Until short, we had Mr. Tacho Barefoot, used to be the representative for St. Martin on the board of the Sabre Bank Resources. And soon he is going to be replaced, and that is on the next shareholder meeting that will take place on June the 17th. He will be replaced by Mr. Kevin James, will be the next replacer instead of Mr. Tacho Barefoot. Madam Chair, these are the answers that I can give immediately concerning the huge amount of clarifications that has been asked, and if possible, I will send in writing the rest of the expected clarifications.
Before I allow you to go or to sit, Prime Minister, allow me to have MP York make his interruption. MP York.
Thank you, Madam Chair. Madam Chair, I'm on the record oftentimes commending the Prime Minister for not dilly-daddling around questions and actually answering all the questions that are normally posed to him. Until now, Madam Chair, if the Prime Minister needs to seek legal advice or to sit with people at the same minefield to answer simple questions like, if one minister is being held accountable for this action, will every minister moving forward engaging in this type of conduct be held to the same standard, that he needs to have legal advice? If I ask a simple question, if a Prime Minister cares so much of the healthcare matters and legislation under VSR, why did he not become the VSR Minister instead of the Prime Minister? If I ask a simple question as if skipping advices was previously defended as male advisory before, why is it now being treated as a serious legal issue? I see now the legal advice was given, so I hope right now I can get an answer to these simple questions that I don't think the Prime Minister needs 2 weeks to answer. Thank you, Madam Chair.
Thank you, MP York. Prime Minister, you have made your position regarding coming back on the outstanding questions or the clarifications. And before we determine the time during which that will take place, MP Iran, you have an interruption. You have the floor.
Thank you, Madam Chair. Madam Chair, the Prime Minister, again, did not answer my question. I asked specifically, since the Prime Minister has deviated currently, as Mr. VSR regarding hiring of individuals, why can that be done similarly to hiring individuals with the whole big registration? Is that also possible? In addition to that, the Prime Minister mentioned that he didn't say that persons in St. Martin are uneducated. And again,
educação. Nós nós compreende o nota educado em nosso país.
That's not my words, Prime Minister, or MP Doran's words. That's your words. And saying exactly that incorrect. So thank you, Madam Chair.
Thank you, MP Iran. The reason why I said MP, I was just going to remind you that you are there for interruptions, but nevertheless, you just kept it very short. Prime Minister, again, is there anything mentioned now that you can react to now? Or otherwise, we shall go over to establishing when we'll get the balance of the questions and clarifications. Prime Minister Marcelina.
Yes, there is one more clarification that I can go in now to is the statement of MP Shamira Roseberg. She asked if I'm not mistaken, if mediation has been considered in the situation that occurred between Minister Brugge and the URSM party, and if a mediator was used, the services of a mediator was used. Initially, it started in the beginning of 2025, and somebody said correctly that I said 2026, but it's 2025. And we started already in 2025 talking and discussing with the minister. At that particular moment, we did not see the need for a mediator. And when I have to admit that Mrs. Roseburg came at a certain moment and proposed a mediator as a possibility to see if we can get to a solution. She did it, but it was later on and almost a year later, and it was already when that proposal was discussed, it was already, in our perception, a little too late to call in a mediator in that phase. But indeed, for sure, Mrs. Shamira Roseburg, MP Roseburg, proposed that as a possible approach to the problem. Thank you, Madam Chair.
Thank you, MP. Thank you, Minister of General Affairs, Prime Minister Luc Mercelina. Prime Minister, members of Parliament, ladies and gentlemen, we were and are at a stage of the answering to clarifications. The Prime Minister has given responses to some of the clarifications, and some still remain to be answered. I look in the direction of the Prime Minister and ask what time is considered necessary to respond to the remaining clarification questions. Prime Minister?
Yes, Madam Chair, if you give me the permission for 1 week, by end of next week, for sure, the members of Parliament will get a written answer on the demanded clarifications that they are requesting.
So, Prime Minister, you are suggesting for the remaining clarification questions, you send these in writing.
Yep.
Members would receive those, and then subsequently we continue with the second round of this meeting. Is that the proposal?
That's partially the proposal. The proposal was for the clarification reaction that
yes.
I will have to give. That is in a week time. So by end next week, I will have them. And my second request is if we can proceed with the second round of this public meeting, and I can immediately then note all the questions and send them additional to the answers on the clarifications in one package.
Prime Minister, the part with you sending the remaining clarification answers to the members within approximately a week's time.
Yes.
After which I will then convene the continuation of this meeting for the second round, and the second part of your proposal you will then do at that time. So when we convene the meeting to continue with the second round, you can, and you hear the questions from the members, you can then suggest that those two be answered within what period of time, and you send those questions into Parliament.
Yeah, depending how many questions there are.
Precisely.
And we will determine then how much, so how many days we need. But in principle, I thought as a proposal, it's of course your prerogative, Madam Chair, for us to proceed with the second round now, see if we can continue with noting all the answers, and then we determine, depending on the amount of questions, how many time I need to give answers to all of them, and I can send those in writing too.
Am I understanding your proposal to be, while we await the other responses to the clarification questions, that we continue now with the second round?
Yeah, if that is okay for you, Madam Chair.
I look to the members that I could put it officially to a vote as a proposal, Prime Minister, but I already get the sentiments that preferable not. I keep looking at my left, and yeah, so Prime Minister, no, I would suggest we leave that part of the discussion for when, after we receive the answers to the remaining clarification questions, which will include that document that you promised you will send, Prime Minister. That's very important. And then at that time, I will then decide with you when we can reconvene, and then we will have that discussion. I just want to make note of the fact that we have received from the Prime Minister's office via the confidential route during this meeting the entire matter/dossier of the mental health facility and everything surrounding that. So members, that documentation is in at Parliament for your perusal via the confidential route. So members of Parliament, Prime Minister and your support staff, I want to thank you for your participation in this meeting. Prime Minister, looking forward to your responses in approximately a week's time. Ladies and gentlemen, we have come not to the end of this meeting, to the end of this session, at which time this meeting will be adjourned until further notice. Hopefully it can be in approximately a week's time, after which we would have received the answers from the Prime Minister to the questions during clarifications. Thank you all once again, and ladies and gentlemen, for tuning in. This public meeting of Parliament is hereby adjourned.